One and two dispose. For judgment, item number one and two.
We have set aside the detention order as well as the confirmation order in respect to both the detainees on the ground of they were in judicial custody.
For admission, item number three.
I think the extent petition is trying to tension on the 30th May 2024 and the contribution of response to consequential one of for the sake of the case, may I take the court to annex one of the petition. That is the FIR logic. Page 21 of the petition. Page 21. Very good.
Yes.
To the officer in charge, Narcotic Police Station.
Which part?
Page 21 logic.
No,
Next,
which part is the relevant?
logic.
22. Come to 22. Suspected to be heroin.
Logic. Approximately 235 grams. Logic.
Commercial.
Intermediate logic. Under segment.
No, 250 rupees. Come to page 26. This bill petition is for whom? This petitioner?
High Court, yes.
Allowed to go on bail, full bail. You were allowed to go on default bail.
Logic. The special judge has allowed the full bail on 5th May 2006 logic. June.
5th June.
While the release order was taken to jail for releasing the detainee, it was informed that the alleged accused is detained under identity. Only.
Detainee is a lady.
Logic.
Detainee is a lady.
Logic.
Lady. Lady.
Logic.
Lady. Her.
The detention order was served to the detainee only on the 6th day of the detention order being released. Actually issued. Only on the 6th day. Section 3, clause 4 of the PSA was not complied.
Any region? Shown?
Lordship. There's some additional affidavit version.
Where is the service?
Oh, page 45, annexure 10 lodging.
45.
This document was furnished to us by
Okay. When did you receive?
lordship. To the Special Secretary Government of Nagaland, Kohima, subject forwarding of acknowledgement received by detainee Tindaling Houghkeep, Allies Nepo Lodge. Page 45, annexure 10 of the additional affidavit. Lodge.
Additional.
Additional affidavit filed by the next one of the day.
Annexure 6,
Annexure 10, Lodge.
page 45 is annexure 6.
Additional affidavit.
You have filed today, yesterday, right? 9th of August. August petition.
Page 45.
So you mean to say it is beyond 15 days?
5 days, Lodge.
5 days.
But
Showing
under
is-
exceptional 15 days.
Yes.
Exception.
But if goes beyond 5 days, then the state has to record the receipt. Lodge. In this matter.
And
the record- there was a
when is
motion-
the detention order? 30?
30th of May. 45.
NDPS Act. NDPS.
Lordship, the detention order is in page 44 in lecture 6 of the petition. Shows that copy to Mrs. Jeneline Houghkeep, care of Superintendent of Jail, Bimabo. Marshal.
Karanga, may I show the records?
No, for Lordship, I submit the section 3 of the law for not compliant.
Any other antecedent?
Lordship.
Any other antecedent
No, Lordship.
of arrest?
No, Lordship. Only in this case. Lordship, in that matter, page 41 of the petition is relevant. Lordship. The proposal for detention forwarded by the detaining authority, sponsoring authority. Page 45. Page 45. Sorry, Lordship, page 41. Serial number 13, Lordship. Whether the proposed detainee was earlier involved in such activities, no. Page 41 of the petition, Lordship. These documents were forwarded by the sponsoring authority to the detaining authority. Lordship.
Page 41 of the additional affidavit.
No, Lordship, of the petition, Lordship.
Which
Page,
serial number?
page number 41, serial number 13. Lordship.
Did you take that plea as regards subsection 3 of section
Lordship.
3
Lordship.
in your representation?
11:6.
The plea motion. Did you take the plea regarding submission of the, serving of detention order
Lordship.
after 5 days?
Lordship.
Where did you take?
Para 8, Lordship.
Para, there are 8.
Para 8.
In the representation? In the representation?
No.
No.
So we have mentioned that it was served only on the 5th of June, Lordship.
Is there any authority on subsection 3 of section 3?
Lordship.
Is there any authority, any decision on subsection 3?
Lordship. Lordship. Amina Begun versus State of Telangana, Lordship.
Which paragraph?
Paragraph 25, Lordship. This paragraph, Lordship, the appellate court has laid down that.
Specific subparagraph?
The next page, Lordship, number 10. The timeline as provided under the law has been strictly adhered to. 10. The timelines as provided under the law have been strictly adhered to. In this matter, Lordship,
And the next line. Next line, yes.
should the court find, Lordship, should the court find the exercise of the power be bad and or to be vacated applying any of the tests noted above, rendering the detention order vulnerable. Detention which undoubtedly visits the person detained with drastic consequences will call for being interdicted for righting the wrong. Lordship.
Could not find any reasons anyway. Huh? That is guilty. Let's find out. I checked it out. In fact, one of the notes which was given out there, it was to the effect that was the court not informed that there is a preventive detention order. In fact, that means nobody knew about this thing. At least it's the records.
What the important matter, page 53, lecture
53.
9 of the petition is relevant. Lordship. Only on the 14th June of 2024, the public prosecutor has informed the court that the alleged accused has been detained. Lordship.
See page 116, 15.
Constitution. Constitution.
Mr. Counsel, what do you say about Annexure A to the affidavit filed by them? This is under your signature.
What is the acknowledgement certificate is contradictory to the report. Lordship.
But this is under your signature.
Lordship.
Then-
Lordship. Lordship, as per the detention order. Lordship,
Because there is another document, 115. Have you seen it, Mr. Angami? 115 or 116?
Lordship, the detention order, Lordship.
Yes.
Copy to Mrs. Jinelin Hoki, care of Superintendent of Jail, Lordship.
But are you denying the signature or an
This is my
annexure?
signature, Lordship.
Then-
But, Lordship, but the.
This was within
detention-
time, apparently, within 5 days. So for this point is
No,
concerned.
no, Lordship. The communication letter of the superintendent of jail is very clear, Lordship.
No, this document is
This
clear.
document is there,
That is-
witnesses. Witnesses signed, assistant jailer.
Lordship, I was only served on 5th June, Lordship, duly served, Lordship.
Where is that any other evidence? But here there is a clear admission on your part that you have received it on 3.
Lordship, as per the information, as per the communication given by the detainee, she was made to sign. But no documents were given to her, Lordship. Lordship,
Let's see your representation. Did you say that?
That is not said. That is not said.
Where is your representation?
In your paragraph 8 only you have taken that stand,
Lordship.
not in the representation. Now let us see ground of detention. Ground of detention.
Harriet, Lordship.
Which page?
Page 46, annexure 7 of the petition, Lordship. Round number 1, Lordship. In the instant case, 20 nose of case of suspected heroin, sunflower weighing 239 grams were seized from your possession and you, Mrs. Jinhelin, no, okay, have admitted to dealing in narcotic drugs and psychotropic substances, possession, sale, purchase, transportation, and concealment of such illegal substances in various parts of the northeast state of India, confirming to act under Section 2E of the PNDPS Act 1988. Count number 2. That you purchase illegal drugs from Manipur and smuggle it to Nagaland for the purpose of selling them in Nagaland, indicating the interstate network of illegal drugs trafficking. 3. That the case is still at the initial stage. What in this method Lordship is yet to define by the legislation. As well as section 36A. That's not.
What do you say about paragraph 25(9) of that judgment? Hmm. 25A,
Lordship.
25(7).
Lordship. The grounds for reaching the requisite satisfactions are such which an individual with some degree of rationality and prudence will consider as connected with the facts and relevant to the subject matter of the inquiry in respect whereof the satisfaction.
No,
is
no,
to be-
7, Romans 7. Romans 7.
Logic. The satisfaction has been arrived at bearing in mind existence of a live and proximate link between the past conduct of a person and the imperative need detained him or his space on the level which is staying person. Lordship, I have taken this plea ground forward.
Why the materials unearthed during the course of investigation cannot be taken into consideration by the retaining authority? Page 31.
Lordship, all these are unconcluded facts, Lordship.
At the stage of investigation, everything is unconcluded.
Of course, Lordship. As per the detention order as well as the ground of detention, she was detained merely on the ground of admission, Lordship. Admission before the police officer, Lordship.
But that's
And
not a
it-
trial. That's the difference between,
Lordship,
that's the difference between a preventive detention and otherwise a normal detention.
Lord,
You have referred to the judgment of, I mean, the Begum, there also the Supreme Court makes it very
Lordship,
clear,
it-
this is not a punishment.
Lordship, that cannot be done. Lordship, I agree with that. Lordship.
Yeah.
But as of now, they are supposed to be clear that those facts are concluded, Lordship. He was arrested on 6th April, Lordship. So,
Kindly read paragraph 23 of the judgment.
Lordship, this cannot be done, Lordship, of course, Lordship. Lordship. But I suppose that by now, these facts should be concluded, Lordship.
They will do it. They will do it.
Lordship, the state has not exhausted section 36, Lordship, A of the TPS Act, Lordship. In the dawn of the event, it is alleged that I'm involved in networking. But only section 22B was charged against me. So the state has not exhausted section 36 yet for extending the time of investigation.
How? How they will do it? This is not a commercial quantity.
Lordship, Lordship.
That rigors of 37,
Lordship, this
37
section
is
is
not
not
effective.
fit under this category, Lordship. But in the dawn of detention, I was involved in networking, Lordship. So my case is not even fit into section 36 for Lordship, the 36 K of the
Yes.
for Lordship.
They're of the view that you are involved in intra-state
Lordship,
activities
Lordship,
in contraband.
Lordship. And if
That
the
is
state
precisely
that-
page 31. Otherwise, procedural safeguards that they serve on 3-6 within 5 days.
No, Lordship, it was not fully
Document-
served to me, Lordship.
Document belies your state.
It was not fully served to me, Lordship. The letter of the superintendent of jail to.
That may be a different thing, but your signature is appearing
Lordship,
on 3-6-2024
Why didn't-
document.
Why didn't you take that as a ground in your representation? That I was served here, but they have taken my signature on 3-6. Have you mentioned anywhere? That my signature was taken on 3-6, but served on 5-6.
Lordship,
And you moved that application on 5-6 default
Lordship,
bail,
Lordship,
5-6 only, because cause of action to have
Lordship. But during the time of.
default bail is only
Lordship,
was on
Hangami.
5-6.
Lordship, during the time of moving the bail application, neither the state, the prosecution, the court, nor the applicant, the council of the tribunal is aware that detention has been issued against our Lordship.
Can you give us this photocopy of page 115? Okay. Rest we don't require. And in respect to the earlier matters, the records are there. We have returned it.
Regarding the serving of detention order after 5 days mentioned. I respectfully plead that submit that whether that plea has been taken in the representation or not, whatever safeguard has been provided to the detainee, she is entitled to. So the procedural safeguard mandated by law has not been provided, even if the detainee has not make that plea in the representation. She is entitled. She is entitled to that safeguard portion. Another precaution, I also want to take that, the state as well as the Union of India has delayed in disposing the representation lordship.
How much time?
Lordship,
When will it do disposed of?
only after 16 days by the state.
Is there any timeline?
No. lordship.
Mandatory
No,
timeline?
lordship. No timeline. lordship.
And where is the advisory board?
They have not furnished law. lordship.
Hmm?
The report of the advisory board was not furnished last lordship.
And give us a copy of the advisory boards.
Heard Mr. V. Siri, learned counsel for the petitioner, Mr. K. V. Angami, learned public prosecutor for the state of Nagaland, and Mr. Yangavati, learned central government counsel for the respondent Union of India. Arguments are hard. Judgment is easy. Yes. Anything on it?
Lordship, I want to rely for 18, 21, and 25 for this case.
What is the disposal of representation order?
Page 54 and next year for being additionally. On
The central government?
Central government, the next page, annex of 15 on 27th
Page,
August,
page,
page 55. Lordship.
in the writ petition or additional affidavit?
Additionally,
Tell me.
You gave on 11/6 representation.
Lordship.
Is there any explanation by the state?
No, Lordship.
As
No,
regards
Lordship.
why it has taken 20
No,
years?
Lordship. No explanation was made by that. Lordship.
Yes, please.
Lordship, para 22 is also relevant, Lordship. 22 of the put on by Sheikh versus magistrate on the para 22, Lordship.
Gauhati, you have filed affidavit? You have not.
That is a, cannot be a plea. Union is required to dispose the representation in an expeditious manner.
Lordship,
Is it a law that the detainee is to be informed that you are at liberty to prefer representation before these authorities at the time of serving the detention order, right? And you have filed all the representations before the appropriate authorities,
lordship,
right?
lordship.
Now, is it a law that all the authorities are required to dispose of the representation in an expeditious manner, or only disposal of the representation by one authority will be sufficient?
All the authorities has to dispose their representation, lordship.
Mhm. And expeditiously.
Lordship, lordship, para 22, lordship.
I think. Mr. Gandharvati, there is some inexplicable delay in disposal of the representation on the part of the Union of India. It appears that you dispose of the representation on August, that is
27.
27th August. Whereas the representation was filed as far back as on 11th of June, perhaps. So I think Union of India owes an explanation. Hmm? So get the instructions in writing why it is delayed. Because this judgment says
No, take it up next week.
next week from the principal seat.
Principal seat will take. So it by week.
Lordship, may I be allowed to read para 22, lordship?
We have read.
Lordship,
That is why we have asked.
lordship.
Where is your submission of any evidence regarding submission of your representation before the Union of India? True.
True, there's a good.
Huh? Where is your statement? Any statement is there? In the writ petition? रिप्लाई दिया नहीं हमने दिया नहीं एडिशनल एफिडेविट और क्वेश्चन एडिशनल एफिडेविट पहला 30 Heard, Mr. VCD. Oh, Argonza had not heard myself. Uh, Mr. Siri, learned counsel for the petitioner, has submitted that after the order of detention dated 35/2024 was served upon the petitioner, the petitioner submitted a representation before the central government on 11/6/2024, seeking revocation of the order of detention passed against him. Full stop. It was after 75 days of making the representation, the central government by its memorandum dated 27/2024 had rejected the representation. Full stop. In such fact situation obtaining, it's and a representation submitted before the notified authorities is required to be disposed of at the earliest, and no affidavit as on date. No affidavit has been filed on behalf of the respondent Union of India, explaining the period of delay regarding disposal of the representation on 27/8/2024, Mr. Yangarbati, learned Central Government Council, representing Ched and Guli, shall obtain written instruction on the next date fixed. The council for the parties have been substantially heard in this matter of preventive detention under Section 3 of the PIT and DPS Act. Full stop. In such view of the matter, this bench deems it appropriate, in view of ensuing winter vacation, in view of ensuing the winter vacation. And the Kohima events on and from 13th of December, 14th, or 14th, that's 14th of December, 14th of 2024 to 16th of January 2025. Find it proper to hear the matter further at the principal seat on on another date at the principal seat Two, the video conferencing. Showing it as a part of it. The registry shall provide scanned copies of the case papers at the principal seat. Sent to the principal seat for when will be too late. Eh? 20.
For admission, item number 4.
File plan.
Of the similar method logic. I was detained the section one of PIT and EPS Act. Save the precious time of this on court order. There's clear violation of section 3, subsection 3. And Article 22(5) maintains that it has to be detention orders along with other grounds has to be communicated within a period of 5 days.
We thought that in the earlier matter also, but documents in the record belies that submission.
And the government, interestingly, Lordship, the government has filed the affidavit yesterday. Perusal,
Which is not with us.
it has admitted, Lordship.
It is there.
Government has admitted, Lordship.
Is it?
Page 10 of the government's affidavit. Lordship.
Detention order is 28 March
March.
2024,
Lordship,
and it was given on 11/4,
Lordship,
and there's no reasons.
no reasons, Lordship. And section 3(3) clearly says, if it is beyond 5 days, reasons has to be recorded in writing. It's, the affidavit is silent on detention.
Means 14 days.
14 days, Lordship.
What is their statement? In the affidavit?
Lordship, when it comes to paragraph 12, Lord. Paragraph 12. This pertaining to the acknowledgement in the annex. Page 5, paragraph 12. May I read it, Lordship? The averment made in paragraph 22 and 23 of the read petition is denied by the answering respondent. Here, it is pertinent to point that the rights of the petitioner have not been interfered in any manner. The detention order, related documents, and enclosures highlighting the grounds of detention and information to detainee aspiring him of his rights dated so and so have been served and acknowledged, receipt duly signed by the detainee obtained. The signature of the detainee appended in the acknowledgement certificate in so and so proves receipt of the same within the stipulated time period. No explanation as to why it was served only after 5 days.
Where is the detention order?
Not will find page number 44, Lordship. Page number 40. Lordship. May I read?
Why did you wait till 15th October to file a writ petition?
Lordship, I have approached this on court earlier, Lordship.
Oh.
And while pending, Lordship, the extension, the detention order was extended. So I have withdrawn and challenged the latest extension order, Lordship.
Because if the original order is bad,
Lordship,
the subsequent order would have been bad.
Lordship.
Why did
That was
you
because
withdraw?
Lordship, to the knowledge of the earlier council, Lordship.
Where is the withdrawal order?
Lordship, may kindly come to page 29, Lord. Sorry, page 29 of.
24/7. Was
Yes,
any
Lord.
counter affidavit filed in that writ petition?
No, Lord.
Huh?
No contact.
In that writ
Yes,
petition?
Lord, as per the instruction I have received, Lord.
Your period is ending on 27/12.
Yes, Lordship. 27/12, Lordship.
Where is the origin, detention order, page?
44, Lordship.
An extension order?
Extension order, Lordship, will find at page number 84, Lordship. Second last page, Lordship.
There is a confirmation order
Confirmation order, and it has been extended for 3 months, Lordship.
on 85.
Litigation.
And the latest extension is
27/12.
page 85, Lordship.
Thereafter? Oh, 27/12, 27/12. Yes. Yes. What do you say about this order in your own affidavit? No explanation. It is your own admission. Yes, Mr. Engavati, what do you say?
It's a letter from the Ministry of Finance. Lordship, I don't know what to do because by this letter, the state government has been requested to file the affidavit on behalf of the central government.
Yeah.
Next, Lordship, page 2, verify. However, Lordship, the explanation has been given at para 3.
There are three.
Yes, Lordship.
There is no internet? Wi-Fi? Where is the judgment in Ankit Jain?
Jalan.
Ankit Jalan?
Ankit Ashok Jalan.
Ankit.
Any idea?
No, no.
Jalan.
So, Mr. Yamavati, in the earlier case also, that may be the explanation. Paragraph 55.
Or in this case, we have 39 days in positive representation by a single government. 39
There is an explanation on the part of the central
Yes,
government. Right, Mr. Mohan Ramesh, Learned Counsel for the petitioner. Mr. P. Jimomi. Learned Public Prosecutor. For the state of Nagaland. For respondent number 1, 2, and 3, and Mr. Yangarvati, Learned Central Government Council for the respondent Union of India. Green record, the respondent number 4. Arguments are high. Judgment is. Oh, Mr. Mr. Ingravati has placed a communication bearing number F so and so dated 18/11/2024 of the Government of India, Ministry of Finance, within bracket Department of Revenue, that's PIT NDPS Division, bracket close, Ministry of Finance, Government of India. In support of his summary. And the same is marked as document X. We have perused the records placed by Mr. Jimomi, Leonard, public prosecutor for the respondent state of Nagaland, as regards the detention order and other proceedings regarding the petitioner detainee. And the records have been returned to Mr. Jimomi.
May I supply these authorities in support of my.
Board. Board.
Question.
For admission, item number 5.
Mr. Lordships, I have filed my additional affidavit this morning, Lordship. I believe it's on the record, Lordships. Lordships, I have annexed all the annexures that I have annexed in the writ petition, Lordship. And the affidavit is sworn by the brother-in-law of the detainee, Lordships.
What is your case?
Yes, Lordship. I have my first ground is, although I have some other few grounds, Lordship, I'm pressing on the subjective satisfactions, Lordship. So Lordship, here while the detaining authorities were passing the detention orders, Lordship, they failed to satisfy that the compelling reasons, Lordships. Though they have passed the detention order, though the detainee was still under the custody, Lordship. In fact, Lordship, the detainee was arrested on 16th 16th, however, Lordship, the detention order was passed on 22nd of February, Lordship. That there was only 5 days in between, though he was under custody, Lordship. So
Detention order is 23rd.
22nd, Lordship, and he was arrested on the 16th, Lordship, 16th of February, Lordship. So my first ground is on that, Lordship. I have also some citations relying to support my contention. The detention order is at Annexure C of my additional affidavit, Lordship, which is at page 33.
Page 33.
Lordship.
Why it is mentioned to detain him under subsection 2 of section 3? Then why it is next para? In exercise of power conferred by subsection 3 of section 3? Page 33 of your petition.
Lordship. Lordship, in my
NSA,
case.
NSA.
Yes.
You are under UPA, arrested under section 10.
Lordship, he is alleged that he is, yes, Lordship. However, Lordship, there's not, if we go by the material and facts, Lordship, there's nothing on record to show that he is the offenses that has been alleged has been committed by the detainee, Lordship. In fact, he was on his own, Lordship. The FIR is page
What
21,
is section 10 UAP Act?
Lordship. Lordship, this is regarding the penalty for being member of an unlawful association, Lordship.
And it is a man organization,
Lordship, they have alleged, but
NSCNK Angmai.
Lordship, they have alleged, yes.
No, is it in the schedule?
Schedule,
No, Lordship, it's not.
NSCN and all other its faction like that, it is there.
No, Lordship.
So please see.
Yes, yes, I think. He was the UPA.
Unlawful Activities Prevention Act. Schedule in the schedule.
Lordship, there's nothing in the schedule I have. seen.
NSCN is not there.
This the.
Don't say that.
It's a schedule, but,
Yeah, see, last 39, National Socialist Council of Nagaland, A. All its formations and front organizations. See the first schedule. Isn't it? And serial number 39.
which is.
You're not worried.
No, Lordship, I have not. My apologies, Lordship.
When the hell? You must have got an old book, I suppose.
However, Lordship, with regarding the association of unlawful, though not admitting Lordship, even assuming he is Lordship, there's a ruling, Lordship, that mere association with an unlawful assembly cannot criminalize a person, Lordship. And in fact, here the detainee was on his own personal duty, Lordship. And There is nothing on record to show that he was,
In the bail application,
no, lordship, there was none.
how a bail is being taken under this act?
Lordship.
Forty-three D. He's inside,
No, lordship. No.
he's out.
Oh, no, your lordship, he's inside, lordship, but. Oh,
What is NSR? Nagaland Security
regulations.
What is that? Let us see. 7. To separate.
Lordships, rule 7, that section 7 is for penalty for subversive act.
Where is 7?
Lordship, I have marked it.
Yes.
What is your affidavit?
The ground part, paragraph 6, you mentioned.
Yeah, what was the basis that within 4 or 5 days, you have put him under preventive detention? What is your basis to put him under preventive detention after 4 or 5 days from his arrest? He was already in judicial custody, police custody, if you will. 4 or 5 days he will be there, arrested, and 5 days thereafter you have put him under preventive detention. There has to be some materials that you want to do it. Merely because he has 8,000 rupees of extorted money in one slip and a G22 GPA. Do you have anything?
As far as the report speaks, right?
And there was no question of the investigation default bail or anything at that point of time. So there has to be some material that he is going to get bail.
Chief, that the instructions, because this matter was taken up by that one, and since the matter was supposed to be resolved. That instruction.
Yes, anything in support?
Yes, Lordship.
Right.
Lordship, in fact, I have 6 or 7 citations which are like I've made of.
Rekha. Liquidity.
Your Lordship, I also have the judgment passed by this honorable court. In fact, the Lordship was also one of the judges. If I may be able to bless this.
Heard, madam?
You can hear Lordship.
Mika
H. Green.
Ichai. Learned counsel for the petitioner. Miss Livika. Learned state counsel for the respondent state of Nagaland. And Mr. Ingervati. Learned central government counsel for the respondent Union of India. Arguments are heard, judgment is reserved. Record. records. Madam, you place some photocopies by tomorrow. Right? To me, from the records. We are indicating the page number. We are not retaining records.
Madam, we require the advisory boards report. Advisory boards report, and it will like the rejection, the rejections.
Records relating to detention of the petitioner detained, placed by MS Lipika, are produced and the records have been returned to MS Lipika during the course of hearing. Then arguments are heard. Judgments. So disposal of the representation of those orders and advisory board opinion. Replace, if possible today or otherwise.
Much resolutions.
This is logic. Lordship, I am praying for your lordship indulgence.
Yes,
Yesterday's part third matter, lordship.
Yes.
Is stated. Supplementary item.
Supply.
49.
Hmm.
In fact, this is only the part third, it is the only part third listed today. Mother, may I pray that this matter be taken up after the motion items, so that we complete it.
okay.
Okay.
The matter was taken up on 10th of December, yesterday. It was supposed to be listed today, but in the process, it's not reflected, Your Worship.
Hmm.
So as such, I inquired from the registry, they said to find a better memo.
Then
Here, I sincerely beg the lordship's apology. My client is out of station. I could not get the information that I needed to file an affidavit. So I beg the lordship to kindly give me some time so that we can fix it after the vacation, my lord.
this is, I was granting you that opportunity
Yes, your lordship.
despite
I seriously appreciate the lordship's.
reaching a
opportunity.
privacy satisfaction. So that every opportunity is granted to you.
I will try my best to file an affidavit that will satisfy this on court, my lord.
Okay, we'll post this matter tomorrow.
Since my remonstrance is.
No, it is not possible, madam, today. It is also not possible also. We'll post the, I'll mention you tomorrow. We'll see if we can partly heard, we'll do it. Then thereafter, next hearing will be from the principal seat.
My lord. Your lordship.
That much we can do. Not possible today.
Your Worship, then I'm praying that the matter will be taken up in January in the principal seat.
No, that I cannot. That I can. No, I'm. Because granting opportunity to file affidavit is not part heard.
No.
Meaning thereby pleading is not complete. Right? So I cannot do it part heard. It is not possible. So then, after vacation,
No,
you have no other option.
your lordship. Obliged, your lordship.
File a mention memo showing a date in January. Then I'll allow that mention memo.
Obliged, your lordship.
You allow it. What is the date?
Next, lordship.
Yes,
Lordship, I think mention item 12, lordship.
item 12.
Lordship, for the petitioner, I'm yet to file my reply.
Okay.
Can you send me some time, lordship?
Yes, who is the state counsel? Mr. Foseko Fote, learned counsel for the petitioner, and Ms. S. Mere, learned state counsel for the respondents are present. First of Mr. Fote, learned counsel for the petitioner has paid for and is granted. How much time?
Lordship, this is 3 weeks, lordship.
3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the state respondents.
Lordship, this is interim.
The interim order, if any, shall continue till the next date of the state.
Lordship, a similar period for item number 9 and 10, lordship.
Hmm.
There's some yet to file my reply to the affidavit by the corporation, lordship.
Okay, who is for Mr.
9 and 10.
Im Chong? Oh,
9 and 10.
Mr. Foseko Fote, learned counsel for the petitioners. And Mr. Im Chong, learned additional AG.
Lordship, is corporation.
Okay, learned counsel for the respondent corporation authorities. Are hired, full stop. Mr. Fote, learned counsel for the petitioners has paid for and is granted 3 weeks time. Affidavit in reply to the affidavit in opposition filed by the respondent corporation authorities.
Maybe please mention item number 30 and 31. 30 and 31. Your Lordship, in 31, I have filed my affidavit. However, in 30, I am yet to file. So another 3 weeks another will come after vacation for filing affidavit.
MS learned counsel for the petitioner is present. Ms. Trivika, Learned State Council has submitted that a counter affidavit on behalf of the state respondents has already been filed in 31. However, the counter affidavit on behalf of the state respondents in 30 has not yet been filed. Post up. CS does pray for further 3 weeks time to obtain necessary instructions and to file counter affidavit on behalf of the state respondents in 30. The prayer is allowed. The state respondents shall file their counter affidavit in item 30 within 3 weeks, release the cases after 3 weeks.
Your Lordship, I would like to mention item number 14 and 15. Your Lordship, I have responded number 1, Julian. 3 weeks time may be granted to file my affidavit.
Your name, please?
Yeah, thank you, Lord.
YT Gupta.
Lordship, and for the petitioner here. Since after granting them last chance, this is the 3rd time they're seeking time again, the respondent 1 in both, and also respondent 10 in item 14 and respondent 9 in item 15. This is the 3rd time.
What are the subject matter?
It's regard to damage compensation.
Damage compensation, 1910.
Your Lordship, our reply was ready, however, it was sent for the approval in Delhi. So the last opportunity may be given, Your Lordship.
There is no such observation regarding last opportunity.
No, Lordship request.
And the last order was 19/11/2024.
There was some order was that it was possible be enforced, mayor of.
But that has been diluted by the subsequent order.
But after that, even after that, they're seeking time and
Miss
for me to get to.
Learned Counsel for the petitioner is present. Mr. YP Gupta, Learned Central Government Council for the respondent number 1 in both the
Yes, Your
writ petitions has submitted that the counter affidavit on behalf of the respondent number 1. You're going to file 1 or 2?
1.
1. So, a consolidated counter affidavit
Yes.
on behalf of the respondent number 1 in both the writ petitions is going to be filed within 3 weeks' time. It is submitted that the counter affidavit has already been prepared and the same has been sent for vetting. And the same will be filed as soon as the vetted counter affidavit is received. Full stop. Anybody else not filing affidavit? MS Pichano.
Respondent 9 in PPPC 321. Respondent 10 in PPPC 321 and respondent 9 in 236.
Okay. Pichano Learned State Council appearing for respondent number 10 in 14 and respondent number 9 in 15 has also sought for and is granted 3 weeks time to file the respective counter affidavit. Huh? Then who is appearing for an
Apila.
Apila? You are Mr. Gupta, you are Central Government Council.
Yes, Your Lordship.
On the previous day, 10 and 9, in the other affidavit,
Yes, sir.
Apila Sanctam, she is also Central Government Council.
It's for a company.
Just a minute, just a minute.
Lordship, C is for the company.
Hmm?
C is for the company.
Let me check myself. Item number 9 and 10. 321. That is a company, not Central Government Council, not, it is a private company.
Yes.
Okay, MS Pichano, land so and so, land state council, paying for the state respondents, has submitted that counter affidavit on behalf of the state respondents has been filed already, has already been filed. Okay, full stop. Where is MS Apila Sanctam? Okay. There is no representation on behalf of the respondent number 10 in 14 and respondent number 9 in 15 today on call. Full stop. As time has been granted to the respondent number 1 to file their counter affidavit, comma, the respondent number 9 in 15 and respondent number 10 in 14 are also granted 3 weeks time to file their counter affidavit.
Obliged.
This is the case after 3 weeks.
That is wanted. I think we mentioned item number
8.
Lordship, on behalf of Petitioner GLD Sandana.
Ah,
And grant 3 weeks time to file affidavit.
MS
And for every petitioner.
present. MS Picharon, Land Council, State Council representing Mr. LT Sanctam, Land Traditional AG, Nagaland, has prayed for and is granted 3 weeks time to file counter affidavit on behalf of the state respondents. Mr. Sentia Anger. Sentia Anger, Land Council for the 1, 2, and 3. Is you are filing also? Okay, is in attendance. 1, 2, and 3.
Lordship, similar prayer with item number 24.
Representing what?
State.
Okay, state. Mohajami. Learned Council for the petition is present. Ms. Pichano, Learned State Council, has prayed for and is granted 3 weeks time to file counter affidavit on behalf of the state respondents. This is the case up to 3 weeks on a date to be fixed by numbers.
Lordship, I also like to make a mention hearing item number 36 and 37.
36.
And 37.
Hmm.
Can you this letter after vacation?
MS Kekrienso. For the petitioner is present. No objection? MS Pichano, Land State Council, has sought listing of the cases after the ensuing winter vacation. As the prayer is not objected by the Land Council for the petitioner, list the cases after the ensuing summer vacation, winter vacation on a date to be fixed by the office.
Lordship, similar prayer with item number 33, 34, and 35. On behalf of Inal.
In the list, how many cases? In the list in your hand, how many cases? Few list. Yeah, curious, Learn a council for the petitioner is present, same previous order. Representing MS Inaholi, Learn State Council.
Lordship, I also like to make a mention 41 and 42. I think this is after vacation.
Where is Mr. Ponjana? Yes, MS present. You appear in this case or you are representing somebody?
Fine.
Okay, Pichano. Same 3 weeks.
The lordship, I don't know for deals on the other in our
Inaholi.
lordship. Can you discuss the draft application?
Okay. MS for the petition is present. Inaholi. 3 weeks.
I pledge.
No, please, my lord. Lordship, I beg to mention item number 27, in fact, 26 and 27 is listed together.
Hmm.
Lordship, item number 26, I'm not appearing. Item number 27, I'm appearing, Your Lordship. Perhaps, Your Lordship, this item number 27 is wrongly listed today.
Actually, it was on my mention because 26 and 27 are of the same nature, same department, all in one of the areas. The placement area, Your Lordship. And 26, my lord, apparently some instruction has come, so it covers both. My lord, here, the placement area is for all the employees, all the professors, Your Lordship. My clients have retired. A similarly situated person has already been released of the placement area. And in our case, Your Lordship, in item number 26, there are 2 petitioners. Item number 27, Your Lordship, there is 1 petitioner, my lord.
But whether he has received instruction?
No, Your Lordship, in fact, Lordship, by an order that is 6/12 of 2024. 6/12 of 2024, this honorable court has listed a matter again on 24/1 of 2025.
My lord, I.
24/1 of
Let us see
2025.
26, 27.
Yes.
It's on my mention memo, which was allowed by this honorable court, my lord, that it's listed together because it's of the same issue.
Mr. Angami, you appear in which item?
Item number 27, my lord. WPC 260 of 2024. The
In
matter was listed on the Lordship.
In item
6/12.
number 200, WBC
No,
2024.
yes,
200.
260 of 2024.
Moaim Chen, senior government.
Yes, I'm not on 26, Your Lordship.
Moaim Chen is present.
Personal difficulties.
There no instructions are awaited. Item number 26.
No, my lord, here, what I'm trying to request
No.
is honorable court is that a similarly situated person, I have placed everything on record, my lord.
Mr. Council, the person who is holding the brief is not present.
I was shown a paper by my learned friend appearing for Mr. Moinchin, item number 26. Apparently some instruction has come. But my lord, here, whether
Still
it is,
awaited.
Your lordship, the history of this case is that whether affidavit is filed or not.
No, we are only at the mention hour,
Yes,
not a hearing hour.
Then my lord, let the matter come, yes, your lordship. God bless you, lordship.
I think mention item number 51, 52 from the supplementary. The IA, I'm for opposite party number 1. Near to file my affidavit of approach.
In I 51, item 51.
In both, IA 198 and
51, 51.
yes, item number 51.
What kind of IA? Order 41. Rule 27. You want to file objection?
Yes.
Okay. Mr. Siddhi Rangsang, learned counsel for the applicant is present. Mr. Jed Kulnu. You are for the insurance company?
Yes.
Okay. Learned counsel for the opposite party. That's the insurance company. As you see, you are seeking time
Yes.
to file objection.
Objection.
How much? Has paid for and is granted 3 weeks time to file objection to the instant interlocutory application. Post of lays the case after 3 weeks, 51. Okay, what is 50?
52, zero.
Okay. Okay, objection to the IA interlocutory application, IA Civil 198/2024. Post of. And what is the IA in the other one? Same.
Same.
Okay, and IA Civil 199/2024. Applications, huh? Release the cases after 3 weeks.
Lordship, I'd like to mention item number 17. Lordship, we have submitted the representation to the district administration. The response is awaited. Therefore, I think is the matter. Actually,
On the prayer of Mr. C.D. Rangsang, Learned Counsel for the petition, item 17. Release the case after 3 weeks. As the prayer is not objected to by the Learned Counsel for the respondents.
no.
Uh,
Lordship,
The Lordship, I'd like to mention item number 55 from the supplementary assignment. Here I received the additional affidavit filed by the private respondent member. So if I may be granted some time to file a short reply. And if the matter
Okay.
can come up on the.
MS Esther
Ms. Lucino.
Lucino, Learned Counsel for the petition has submitted that she has received a copy of the additional affidavit in opposition filed by the private
Private.
respondent. Full stop. She has submitted that how much 3 weeks time be allowed to the petitioner to file a reply affidavit to the said additional affidavit in opposition. Full stop, Miss. Yes,
Sure, the matter can come up on 27th of January.
Mr.
Sentinel for Lordship.
Sentilong, Learned Counsel for the respondent number 3 and Learned Counsel for respondent number 1 and 2 are present. As sought for and as agreed to by the Learned Counsel for the parties, release the case on
27th of January.
27. Yeah.
I also like to mention item number 54. my lord.
54.
Here I'm paying for the petitioner, Lordship. I have some difficulties today, so if this can come up after the vacation.
Expressing personal difficulty on her part, MS Lucino, Learned Counsel for the petitioner, has prayed for listing of the case after the ensuing winter vacation. Full stop. Public prosecutor, anybody?
Mr. Vijimo is appearing. I
Okay.
have
It is submitted that consent has been taken from Mr. V. Jimomi, Learned State Counsel, to make the prayer. List the case after 3 weeks.
I also like to mention item number 13, my lord. 1
Yes.
Here I have received the counter filed by the state, my lord. So if I may be granted some time to file my
Okay,
reply.
Ms. Lucino, Learned Counsel for the petitioner has prayed for and is granted 3 weeks' time to file an affidavit in reply to the affidavit in opposition filed by the state respondents. List the case after 3 weeks, so 92 weeks by the office.
Lordship, I'd like to mention item number 4. Your state is yet to file affidavit, so can we grant treats?
MS IME, AIME, Learned State Council has submitted that has prayed for 4 weeks' time to obtain necessary instructions and to file counter affidavit on behalf of the state respondents. Full stop. MS. Item 4,
Yes, Your Lordship, item.
you have informed.
Yes, Your
It is
Lordship.
submitted by MS IME that consent has been taken from the Learned Counsel for the petition to make the prayer. Yes.
Your Lordship, item number 39 from the hearing list. Yeah, on the joint prayer, can we let the matter come up after the vacation?
Mr. Moajami, Learned Counsel for the petitioner, and MS AIME, Learned State Council have made a joint prayer to release the case. Joint prayer for adjournment and to release the case after the ensuing winter vacation. Full stop. The prayer, joint prayer is allowed, release the case accordingly after the ensuing winter vacation on a date to be fixed by the office.
Petition Lordship, like to mention item number 16. 4 weeks time to file my affidavit for that.
16. Okay, Mr.
That's my.
Nansan, I Learned Counsel for the petition has prayed for and is granted 4 weeks' time to file an affidavit in reply to the affidavit in opposition filed by the state respondents.
Oh, yeah, private and state.
Or affidavits in reply to the affidavits in opposition filed by the state respondents and the private respondents. Mr. M. Langkong, Learned State Council for the state respondent is present. Raise the case accordingly after the ensuing winter vacation on a date to be fixed by the office.
Yes, Lordship. Lordship, I'd like to mention item 29. Prior to 3 weeks to file my affidavit in opposition.
Mr. So-and-so, learned State Council has prayed for and is granted 3 weeks time to file the counter affidavit on behalf of the state respondents. It is submitted that consent has been taken from the Learned Council for a petition to make the prayer. Lays the case accordingly after the answering some petition. After 3 weeks on a date to fix by that. Yes,
Lordship, I also like to mention item 18, 19, and 20 on behalf of senior government appointment. At the last occasion, he was instructed, directed to obtain instruction of the state respondents. But due to, the state respondents at the tourism department, since the event at a sitting, no instruction could be obtained, Lordship. So we pray that the Lordship can be this. I've blocked this, Lordship.
okay, Mr. Santiago, Learned Council for the petitioners. Petitioner is present, Mr. So-and-so, we. So-and-so Learned Council representing Mr. Moaim Chen. Learned State Council, who is appearing in these cases. Has submitted command instruction that submitted that the instructions from the respondent department could not be obtained till date. He has thus prayed for listing of the cases after the ensuing winter vacation on a date to be fixed by the office. List the cases accordingly.
I will please, my lordship, I am available to make a mention for item 21. This is a consensus prayer. If the matter can be taken up after the winter break, my lord.
Okay. Mr. Santiago, Learned Council for the petitioners, and Mr. N. Angami, Learned State Council, have made a joint prayer to for adjournment and to list the case after
The winter break.
after the ensuing winter vacation. First of, the prayer is loud, list the case on a date in the first week of February.
Much obliged.
I can do. What to do? Mention has taken time.
That's what they. M long kumara sini, M long kumara, M, 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 M. Meghaloi. সব তো এইটো সব এম লং কুমাৰে আছে না এম লং কুমাৰ কি আছে এম লোকেল ষ্টেট কাউন্সিল আছে হা এম লং কুমাৰ আৰু একটা আছে দেই এইটো কোন আছে ও 36 37 ছবি কোনটো আছে পাছতে আহিব দেই কৰা নাই নেকি নাই নাই নেকি ঠিক আছে Item number 5.
Pending na ulit po.
About, my work, on the last occasion, Supreme Court has filed order on 6/12/2024. That IA as well as the revision will be heard today.
Yes,
Lordship, item 1 and 2, my lord.
okay.
Item 1, and my lord here, I have raised preliminary objection because the issue involved in the revision purely civil in nature.
Hmm.
And I have questioned the maintainability of the present repetition.
Huh.
What you will see that this repetition is not maintainable. Page 3 of the repetition by. Page 3 of the FLB filed by the state, I'm the state responsible. I'm for state responsible. Page 3, paragraph 1. I have raised preliminary question. So after considering this, lordship feel that this is civil in nature, then this is the question of maintenance will come. And in any case, this revision is not maintainable. May I read it, my lord?
Repeat, yes.
That is your lordship. Lordship, here this is a matter of question of law. The agreement which was executed between the petitioner and the tourism department.
Let us see the repetition agreement.
These all of these deal. And these
Lordship, what happened was that.
No, one by one.
one,
Okay, please project your case.
Lordship, before agreement was terminated. Before-
Let us see the lease agreement. Let us see the lease agreement. Let us see the lease agreement.
Yes, Lordship.
The whole case is based on lease agreement,
Yes, Lordship.
is it not?
Yes, Lordship. Yes,
Yes.
Lordship.
and my lord, the lease agreement which is under challenge is not annexed.
Huh?
Yes, yes.
Lordship will see.
It is there, page 25,
My lord will see.
is it not?
Lordship, there is two repetition. One is 266, 2023 and 234.
Tell me first the lease agreement.
Yes, Lordship.
Take me to the lease agreement first.
Lordship, page number 17, Annex 02 in the WPC 266 of 2023.
17.
117.
Hmm. Okay. This is the agreement.
Yes, yes, lordship,
This is the agreement.
yes, lordship.
And what is this agreement? Page 25.
Question five, this is under agreement which was executed between the resident department, respondent number two, with our respondent number four, hotel controllers.
Okay.
Before even this was terminated, while it
Okay.
was in operation, they have entered another.
Now,
Yes.
tell me, coming to clause. This is not a statutory agreement. Basically, it is a leave and license agreement. Not lease agreement in proper sense.
Yes, lordship, but.
Because it says the land and the assets shall remain the property of the state government.
Yes, lordship.
First clause. Right?
Lordship here,
And come to clause, then you make your submission. Clause 23. First read it. First read it.
the leasee shall serve at least 2 months' notice in advance to the department in case of its desire to discontinue the lease agreement and vice versa.
So you are a lessee.
Yes, lordship.
You have the option to go out,
Yes, lordship.
right? By serving 2 months. And similarly, the department has the option to go out by serving a notice of 2 months,
Yes, lordship.
right? So if you have the option to go out, why not the department has the option to go out? Question is that,
Yes, lordship.
thereby means this agreement, which is not a statutory agreement, it is a non-statutory agreement, though the department is an instrumentality of the state under Article 12, but still it is a non-statutory agreement. Now, tell me, a specific relief act. Tell me that if the desire, was you served with any notice?
No,
Are you
lordship.
served with any notice?
No, lordship.
Huh? Tell me.
I was served notice only when I.
Tell me.
approached Honorable Court.
Tell me, whatever. Serve notice or not?
Yes, lordship.
Take me to the notice.
Page number 53, annex 9.
Annexure 9. Notice to vacate. 2 months notice.
But lordship, here, the question is that.
Invoking clause 20 to 23.
Yes, lordship is right.
Right.
But
Now,
here,
tell me.
before notice was served, they have already hand over the land and facilities to the.
Land is not that land does not belong to you. Clause 1.
Yes, lordship.
Clause 1 of your lease agreement. Land does not belong to you. It is basically a license agreement, not a lease agreement. You are a licensee, actually. It is a misnomer that you are a lessee. Right? You only enter into that room or whatever. You don't have any right over that structure or the land on which the structure stands. Now, section 14 of the Specific Relief Act. Following contracts cannot be specifically enforced. D. A contract which in its nature determinable means terminable. Right? It has the option of 2 months from both sides. Right? Now, tell me, if you serve a notice of 2 months to the department, can department come to the court and say, no, this agreement has to be continued for 3 months, 5 months, 5 years? Can it be said? See from the other side. You have been served with 2 months notice. Now section 41E. 41E. Extra copy you had? No.
No.
Okay. When injunction cannot be granted. Right? Meaning thereby stay on a contract.
I have read that the lordship also taken into account of the arbitrary action of the state.
This is a contract. It is a notice to vacate.
Since this was executed for 5 years, I have made a.
This has to be interpreted. This, yes,
Substantial.
section 73 of the Contract Act. Section 73 of the Contract. You can file a suit for damages and compensations. Why it is 2 month notice? And you see in many contract employment that this employee can be terminated with 1 month notice. Right? Or employee also can. It is not a case of bargaining. It is a case of contract.
In the process, I have suffered injuries. And because of which I got a representation to the department.
Sick damage for 10 crores in a suit. E, to prevent the breach of a contract, the performance of which could not be specifically enforced. Let us read the notice, page 53. Yes, then you approach this court.
Yes, Your Honor. But before this, I approached the honorable court. First, suddenly the notice, they submitted land facilities to the respondent of the fraud.
Land belongs to them.
Yes, they're right.
Structure belongs to them.
Right.
You were allowed to run a catering facility from there.
Right.
You do not hold any lease over that property, though it is shown as a lease. Let us see once again your agreement. Somewhere they say you as a licensee. Under no circumstances the licensee shall have the right to claim the lease premises or the land whatsoever.
If I bring to your knowledge that the execution of agreement between the authority collaborators and the respondent number 2 was executed when this this agreement was still in operation. And being aggrieved by that, I have approached the concerned department to honor the agreement. And they do comply with
They did not honor,
this.
breached. They have breached the agreement. Let us assume. What is your review? Under the law. Under the law, what is your remedy? Since it is not a statutory contract. So, what is your remedy? They have filed. We have seen 2 months notice they have given. That is clearly in conformity with clause 22. But still, let us assume they have violated. What is your remedy? To enforce the contract, that you go to the court and pray that this agreement shall remain in force for 5 years, as we have executed the agreement for 5 years. When there is a termination clause, court will not grant injunction. Meaning thereby, suppose let us not have the notice, remove the notice from the picture. Then you can seek only damages. The example in a employment contract, not in government service, I must say, employment contract. Definitely you will find a term that 1 month notice from either side. Right? A situation may emerge that employee has got a good government job as a managing director of the tourism corporation. He was serving as a clerk. He want to go. Serving 1 month notice. Can the employer retain him? No. You cannot go. Or you serve the notice and immediately on that day you proceed to join. What is the remedy? You have to deposit 1 month salary in lieu of notice period. Similarly, this provision is there because so that the person who has been terminated a business within 2 months' time, he can set up another business somewhere else. This is the reason. And this is the law.
Sir, Lordship here, I'm gonna say.
And yes.
So I answer, I don't.
Have you retained all these vouchers or not?
No.
Then it is your fault.
Well,
Which one is earlier, which one is later?
234.
Why did you approach that time? Let us see. What was the prayer there? You are a doctor running a restaurant.
My time.
Huh?
This one.
Okay.
Academic.
Hmm?
Not medical.
Not medical. Okay, PhD.
PhD.
I thought that you are a medical doctor. Was and set aside. And honor the lease agreement. Okay. Okay. This is the first. Second one. To me, this can be continued for 5 years. Under a law. Not by force or anything. Under a law. Can grant or can enforce this contract by giving a mandamus that this contract must be continued for 5 years? Answer is no.
It's a violation of,
What?
livelihood.
In a contract, business, pure business, there is no question of Article 14.
There is a,
And terms and interpretation of terms and conditions of a statutory contract is not within the domain of a writ court. You have to go somewhere else, not in 226. Anything? Any?
that's the biggest issue because, I made a significant investment here and also, I have around 15 employees where.
Contract Act.
Their livelihood is at stake.
Contract Act. A Korean color thing. Kurien. Korean.
The reason why I wish to say, how we go to the president will.
You have enjoyed the interim order, Mr. Counsel? I declined the interim prayer, but somehow subsequently you got the interim order and made it to continue. State of Nagaland is depriving from a 4-5-star category hotel because of you. Is it not? State of Nagaland has any 4-star, 5-star category? No.
I'm just about to start Kohima and Dimapur.
But not at the cost of injuring the petitioner or.
Seek damages. No. If you are entitled under the law, I would have. I cannot violate the law. We are taking everything together. The both the writ petitions have been preferred under Article 226 of the Constitution of India by the petitioner. Being agreed by the impugned actions on the part of the respondent tourism department authorities. By the responding authorities in the tourism department, government of Nagaland. Please take your seat. Please take your seat. It is the case of the petitioner that he is an indigenous inhabitant of Junevoto district in the state of Nagaland. Full stop. After having entered into a discussion with the authorities in the Directorate of Tourism, Government of Nagaland, the petitioner entered into an agreement styled as lease deed agreement, on 6/9/2022, with the petitioner on one side and the Department of Tourism, Government of Nagaland, represented by the Director of Tourism on the other side. Post. This property belongs to Director of Tourism or Tourism Department?
Tourism department.
Tourism Department. It is stated that where is the description of the property?
Tourist Lodge, Dimapur. Tourist Lodge, District, Dimapur.
It is stated that the respondent Department of Tourism is the sole legal owner of a landed property, that is Tourist Lodge at Dimapur. Full. By the agreement dated 6/9/2022, oh, not before this. Hello? An asset of the tourism department, quote unquote, restaurant, within bracket, catering services, bracket close, unquote, located at the Tourist Lodge Dimapur, was given on quote unquote lease to the petitioner for a period of 5 years as per the terms and conditions agreed upon and delineated in the quote unquote lease deed agreement dated 6/9/2022. As per the said agreement, the petitioner as the lessee stroke licensee was to furnish security deposit amounting to 2.50 lakhs in the form of a fixed special term deposit, within bracket STDR, drawn in favor of the director, Department of Tourism. Full stop. Any monthly rent? Any monthly rent? Any rent per month?
Yes, sir. Yes, sir. 38,000 normal. Monthly rent 925 per square feet. This 38,000 rupees.
Okay.
310. 38,000.
Okay. Subsequent to the execution of the agreement, the Department of Tourism, Government of Nagaland, granted a permit to the petitioner on 8/9/2022 pursuant to government approval on 2/9/2022. Full stop. By the said permit, the petitioner was permitted to run catering services at the restaurant, quote unquote, within brackets, catering services, unquote, located at the tourist lodge, Dimapur, for a period of 5 years, WEF 1/10/2022 to 31/10/2022. The total area wherein the restaurant stroke catering services was to be operated the total, I'm sorry, as per the said permit, the restaurant catering service was to be operated in a total area of 4031.92 square feet. Shekha, I am dictating. If anything wrong, you tell me. At a monthly rent of rupees 9.50 square feet. Full stop. In the said permit dated 8/9/2022, it was indicated that the petitioner was to pay rupees 38,303 as a monthly rent for the restaurant within bracket catering services, which was calculated as per the standard of rates. Standard or what? SOR? Standard of rates. SOR 2006 of the Public Works Department within bracket housing. Full stop. The area of the restaurant catering service was handed over to the petitioner by the director of, so after handing over the area of the restaurant catering service to the petitioner, the petitioner started running the catering services therefrom. Full stop. It is the case of the petitioner, Mr. Romsung. I have heard. No. Then what happened? This agreement came about. Okay. This page 17. No, in the first petition, I'm taking up the first petition. When the petitioner was running the restaurant catering services from the area, in the area measuring 4031.92 square feet, located at Tourist Lodge, Dimapur, since after the execution of the agreement dated 6/9/2022. The Director of Tourism, Nagaland, was found to have written a letter
She reported, earlier in the process, it was on second, after it was sent over.
No, first, in the first petition, you have this much.
That was not in my hand, but RTIA.
No, in the first petition, I am going by the sequence. Was found to have written a letter to the respondent number 4, White Office letter number is 17 of the first petition on 6/10/2023, whereby the respondent number 4 was asked to take over the land and the facility of the tourist lodge Dimapur by 21/10/2023 in order to facilitate a lease agreement signed on 13/9/2023 for construction of a 4/stroke 5-star or higher category hotel with entertainment and retail facilities at the tourist lodge, Dimapur under the public-private partnership within bracket PPP model on design, build, maintain, operate, manage and transfer basis. Right? Full stop. Having learned about execution of a lease agreement on 13/9/2023 for construction of a 4/stroke 5-star or higher category hotel at the same place wherefrom the petitioner was running the restaurant within bracket catering services and apprehending that because of execution of the lease agreement dated 13/9/2023, there was possibility of the petitioner being removed from the said place. The petitioner submitted a representation before the Director of Tourism, Government of Nagaland on 18/9/2023, ventilating his grievances. Post up. The petitioner had the apprehension that despite execution of an agreement with him for a period of 5 years, the execution of another agreement on 13/9/2023 with the respondent number 4 would have the effect, would bring adverse consequences to the petitioner. So the petitioner had highlighted that after the agreement dated 6/9/2022, he had made substantial investment towards civil infrastructural works. Full stop. But, the respondent authorities, even before elapse of 1 year, even before elapse of a period of 1 year, had entered into another agreement with the respondent number 4 violating the terms and conditions of the agreement dated 6/9/2022, executed by them with the petitioner. When the apprehending that the terms and conditions of the agreement dated 6/9/2022 were likely to be not adhered to by the respondent authorities, the petitioner approached this court by instituting the writ petition, instituting a writ petition, WBC number 234 of 2023. Seeking, setting aside and passing of the agreement dated 13/9/2023, executed between the Director, Tourism Department, Nagaland on one side, and the respondent number 4 on the other side. Full stop. The petitioner had also sought a direction to the state respondent authorities to honor the agreement honor the terms and conditions of the agreement dated 6/9/2022. So this is your first case. Then what happened? Subsequent to the filing of the writ petition, WPC number 234 of 2023, the petitioner could lay his hands on the agreement dated 13/9/2023, executed between the Director Tourism Government of Nagaland and the respondent number 4, which is annexed number post. No, between the Department of Tourism, Government of Nagaland, through the Director of Tourism, Government of Nagaland. Immediately after filing of the writ petition, WPC number 234 of 2023, on 12/10/2023, the petitioner was served with a notice on the with a heading, quote unquote, page 53 of the second read petition. Notice to vacate restaurant at Tourist Lodge, Dimapur, unquote. Dated 15/10/2023 by the Director of Tourism, Nagaland. Full stop. By serving the notice dated 15/10/2023, the petitioner was asked to vacate the premises of restaurant catering services at Tourist Lodge, Dimapur within 2 months from the date of issuance of the said notice. Full stop. The petitioner had been informed that the department, the notice had been served by invoking clause number 22 and 23 of the agreement dated 6/9/2022 in order to pave a way for the respondent number 4 to start their groundwork for development of a 4/5-star or higher category hotel at the place of the Dimapur Tourist Lodge at Dimapur. Poster. You file another petition. On being served with a notice dated 15/10/2023, the petitioner approached this court by way of a writ petition, WBC number 252 of 2023. The said writ petition was, however, withdrawn on 7/11/2023 with a liberty to file afresh. After withdrawal of the writ petition, WPC number 254 of 252 of 2023, the petitioner preferred the other writ petition, WPC number 266 of 2023. Assailing the notice dated 18. 15. Okay, 15/10/2023. Full stop. The petitioner had also sought for an interim relief to the effect that till the disposal of the petition, the notice operation of the notice dated 15/10/2023 be suspended. Full stop. In response to the two writ petitions, the respondent number 1, 2, and 3 filed their affidavit in oppositions in both the writ petitions. I have heard Mr. Kinimi Rongsang, H.H. Kinimi, learned counsel for the petitioner, and Mr. A. Jo, learned counsel for the respondent number 1, 2, and 3. Full stop. What about 4? Mr. Kinimi, learned counsel for the petitioner, has submitted that the petitioner had entered into an lease deed agreement on 6/9/2022 with the respondent tourism department, Nagaland, to operate a restaurant within bracket catering services, bracket close, located at Tourist Lodge, Dimapur, for a period of 5 years. Full stop. He has contended that the total area so given in lease to the petitioner to operate the restaurant catering services is 4031.92 square feet. Full stop. After execution of the lease deed agreement, comma, the restaurant area was duly handed over to the petitioner. Full stop. Since after the handing over of the restaurant area, comma, the petitioner had been operating the restaurant within bracket catering services satisfactorily by paying all the dues regularly to the respondent authorities. Full stop. But the respondent authorities in the tourism department, comma, Nagaland, had again entered into another lease agreement with the respondent number 4 for development of a 4/5 star or higher category hotels under the public-private partnership PPP mode for an initial period of 30 years with an automatic renewal clause for a further period of 30 years. Full stop. The said agreement was executed on 13/9/2023. Full stop. Subsequent to execution of the lease agreement dated 13/9/2022, the petitioner had been served with an impugned notice dated 15/10/2023, whereby the petitioner had been asked to vacate the restaurant catering services area at the Tourist Lodge, Dimapur, within a period of 2 months from the date of issuance of the notice. Full stop, sir. Mr. Kinimi has further submitted that the petitioner, after execution of the agreement dated 6/9/2022 and handing over of the restaurant catering services area, comma, made substantial investment towards civil infrastructure, etc. works in a restaurant. Full stop. Though the period of the agreement was for 5 years, but the respondent authorities only after about 1 year, had served the impugned notice to the petitioner to vacate the restaurant catering services area. Full stop. In the event the petitioner is required to vacate the restaurant catering services area from the Tourist Lodge, Dimapur, the petitioner will suffer immense loss, and the investment he had made to operate the restaurant catering services from inside the Tourist Lodge, Dimapur, would not be possible to recover. So, challenging the action on the part of the respondent authorities in the tourism department, Nagaland, as arbitrary and unjust, the petitioner he has termed the actions on the part of the students as illegal and unjust. Post. Mr. Joe, Learned Council, appearing for the respondent number 1, 2, and 3, has submitted that though the agreement executed with the petitioner and the tourism department on 6/9/2022 is styled as a lease deed agreement, comma. It is, comma, in essence, comma, a license agreement only. Full stop. He has drawn attention to clause 1 and clause 2 of the agreement to substantiate his contention. Full stop. He has submitted that in any view of the matter, comma, the agreement dated 6/9/2022 is determinable in nature as clause 23 has provided for a notice period of 2 months from either side for terminating the agreement. Full stop. Clause 22 has further provided that the respondent tourism department authorities shall allow the facilities at the disposal of the state government stroke test tourism department in case of any exigency or for convenience of the state government stroke tourism department. Post note. During the operation of the agreement dated 6/9/2000, during the currency of the agreement dated 6/9/2022, comma, the respondent authorities in the tourism department, comma, government of Nagaland had entered into discussion for setting up a 4/5 star or higher category hotel at the plot of land wherein the tourist lodge Dimapur is located with the respondent number 4, comma, which is an which has the experience of running such 4/5 star category or higher category hotel at different places. Post note. As after discussion, comma, a lease agreement has been executed between the tourism department, government of Nagaland, and the respondent number 4 for setting up a 4/5 star or higher category hotel at the land wherein the tourist lodge Dimapur is located presently, comma, under the public-private partnership PPP on which date? 13/9/2023. It is in view of such developments, comma, the petitioner was asked to vacate the area of restaurant within bracket catering services, which was handed over to him to run only catering services for a period of 5 years. Post hoc. The petitioner was given 2 months' time to vacate in conformity with the conditions incorporated in clause 23 of the agreement dated 6/9/2022. Mr. Joe has thus contended that there was no violation of the agreement dated of the terms and conditions of the agreement dated 6/9/2022. in any view of the matter, he has submitted that in any view of the matter, comma, the contract dated, sorry, agreement dated, agreement, please, agreement dated 6/9/2022 is not a statutory contract, even though the same has been entered into by the Tourism Department, Government of Nagaland, with the petitioner. It is further contended by him that the terms and conditions of a non-statutory contract cannot be challenged in a writ petition under Article 226 of the Constitution. He has further pointed out that he has further contended that since the agreement is determinable in nature, comma, the same cannot be enforced under the provisions of the specific relief act. I have heard the learned counsel for the parties and have also gone through the materials brought on record by the parties to their pleadings. I have also gone through the terms and conditions in from the on a reading of the terms and conditions of the agreement dated 6/9/2022, styled as a lease deed agreement, it appears privacy that the same is a agreement which falls in the category of leave-in license agreement. Full stop. As per clause 1 thereof, the land and the assets within bracket, namely, a restaurant within bracket catering services bracket located at the tourist lodge Dimapur shall remain the property of the state government. Full stop. Clause 2 of the agreement has clarified that under no circumstances, the licensee shall have the right to claim the leased premises or the land whatsoever. As indicated earlier, the land area, total area, wherefrom the petitioner has been permitted to operate restaurant or catering services is 4031.92 square feet, and for allowing the petitioner to operate the restaurant catering services, the petitioner has been granted a permit and permit at a monthly rent of rupees 9.50 per square feet, that is 38.303 per month. Fair. Clause 23 of the agreement has provided that the lessee shall serve at least 2 months' notice in advance to the department in case of his desire to discontinue the lease agreement and vice versa, which means that if the department wants the petitioner, lessee, that is the petitioner, to vacate the area, department asset within bracket, that is comma restaurant catering services area, then it can also serve a notice giving at least 2 months' time in advance to the petitioner to vacate. Clause 25 has further provided that in case of the failure to strictly adhere to the terms and any of the terms and conditions by the lessee, then the state government shall be at liberty to cancel the lease agreement after serving 1 month notice to the lessee. From the aforesaid provisions of the agreement dated 6/9/2022, it is evident that the agreement dated 6/9/2022 is determinable in nature by serving a notice from either side, by serving a notice of at least 2 months to the other side. On the issue, we can proceed. It is true that one of the parties to the agreement dated 6/9/2022 is the Tourism Department, Government of Nagaland. So at first, it is necessary to find out about the nature of the contract, that is the agreement dated 6/9/2022, entered between the contesting parties hearing. Full stop. It will give you 9.1. Clause 1 of Article 299. Next, there are two categories of contract, that's statutory contract and non-statutory contract. Full stop. It is settled that even if a contract is entered into in exercise of an enabling power conferred by a statute, then also the contract does not become a statutory contract. Full stop. if the contract incorporates certain terms and conditions in it which are statutory, then such a contract to that extent can be termed as statutory. A statutory contract a contract may contain certain other terms and conditions which are not of statutory character and which have been incorporated as a result of mutual agreement. Then such terms and conditions in the contract are to be treated of non-statutory contract. Post of the contract, the agreement dated 6/9/2022, which is the subject matter of dispute in this lease, LIS, is undoubtedly falls in the category of non-statutory contract. Nine point two. It has been categorically observed, it has been observed in Kerala State Electricity Board and another versus Korean Kala Till and others, reported in 2006 SSC 293, that disputes arising out of the terms and conditions before that, terms and conditions of a contract which is non-statutory in character, or alleged breaches have to be settled by ordinary principles of law of contract. The fact that one of the parties to the agreement is a statutory body or public body will not by itself affect the principles to be applied. The disputes about meaning of a contract in a contract, covenant in a contract, para 11, or its enforceability have to be determined according to the usual principles of the contract. Every act of a statutory body need not necessarily involve an exercise of statutory power. Statutory bodies, like private parties, have power to contract or deal with property. Such activities may not raise any issue of public law. In the case in hand, the contract between the parties is in the realm of private law as by the agreement dated 6/9/2022, the petitioner was granted, was permitted to run a restaurant catering services from an area measuring so and so, which belongs to the Tourism Department, Government of Nagaland. Full stop. Any dispute relating to interpretation of the terms and conditions of such a contract, which is evidently not a statutory contract, could not have been agitated in a petition under Article 226 of the Constitution of India, full stop, as held by Purian so and so, Supra. That is it is a matter for adjudication by a civil court or in arbitration, if provided for in the contract. Full stop. It has been further held that whether any amount is due, and if so, how much, and refusal of another party to pay, it is justified or not, are not the matters which could have been agitated and decided in a writ petition. Full stop. Para. On a reading of clause 23 of the agreement dated 6/9/2022, as mentioned here in above, it clearly emerges that the agreement dated 6/9/2022 is by its very nature determinable. Full stop. Section 14 of the Specific Relief Act has outlined the contracts which cannot be specifically enforced. Full stop. As per clause D of section 14, a contract which in its nature determinable cannot be specifically enforced. Full stop. Clause E of section 41 of the Specific Relief Act has prescribed that an injunction cannot be granted to prevent the breach of a contract, the performance of which would not be specifically enforced. Full stop. Reading together the provisions of section 14D and section 41E of the Specific Relief Act, it is clear that a contract which is determinable in nature, like the one in the case in hand, which is terminable, which is determinable with notice of 2 months from either side, the terms and conditions of the agreement dated 6/9/2022 cannot be specifically enforced. Full stop. The terms and conditions of the agreement dated 6/9/2022 was entered into after discussion and on volition of the parties. Full stop. The agreement dated 6/9/2022 has indicated that the said agreement was entered into pursuant to a request application of the petition. Full stop. The notice dated 15/10/2023, which was served upon the petitioner, had provided for a period of 2 months for the petitioner to vacate the area of the restaurant catering services wherefrom the petitioner was permitted to operate. Full stop. The notice, prima facie, the notice is not found to be is found not in conformity with clause 23 of the agreement dated 6/9/2022. Full stop. Even if even if it is a case of breach of any of the terms and conditions of the agreement dated 6/9/2022, the relief to the petitioner cannot be granted in the form of specific enforcement of the agreement, terms and conditions of the agreement. Full stop. Even if there is a breach of the terms and conditions of the contract agreement dated 6/9/2022, the same it is not open for the petitioner to specifically enforce those, as the only relief which is open to the petitioner is to seek damages and compensation as per the terms and conditions of the contract, Indian Contract Act 1872. Full stop. Therefore, insofar as the claim of the petitioner that he had invested after being granted, after having entered into the agreement dated 2022, he had incurred he had made substantial investment to operate the restaurant catering services. It is and in view of premature termination of the agreement dated 6/9/2022, in view of the notice dated 6/9/2022, and if in view of the notice dated 6/9/2022, he would incur substantial loss, the relief sought in these two petitions cannot be allowed. Full stop. If the petitioner has a valid claim for compensation and damages in view of premature, in view of the notice dated 15/10/2023, the petitioner is to approach the appropriate forum seeking reliefs. Full stop. Para. In view of the discussion made above and for the reasons assigned therein, this court does not find any merit in the two read petitions. Full stop. For such. Full stop. Consequently, both the read petitions are liable to be dismissed, and they are accordingly dismissed. Full stop. The interim order passed earlier stands recalled. Full stop. There shall, however, be no order as to cost. Para. In view of the order passed, judgment and order passed in the two read petitions, WPC number so and so and WPC number so and so, this interlocutory application stands accordingly dismissed. All them is civil code. I have indicated.
That's in the, it is reflected in the document.
Appropriate forum. Petitioner has to approach the appropriate forum. See section 70 to 73 of the contract. Yes, Mr. Takamasa. There are other motions or what? So many matters in the list.
Just take it up all.
Huh?
It is something with the other motion.
What are the motion? Yes.
From motion item not.
Okay. What are these? Okay. Any motion? Oh, these are motions. Okay. Yes. Item 3. Item 3. Item 3 is.
Lordship, the petitioners.
Huh? Which one? Only ये दो किया ना 1, 2. Give the 3. Yes.
The petitioner before you lordship a research scientist. Followed you were during the COVID-19 pandemic lordship, the state government took a decision to create some posts to address the problems and to mend the two that for COVID testing, the 6 research research scientists, were appointed on temporary basis after 12 open deputies. Thereafter, the cabinet took a decision.
Which one is your appointment decision to selection process regarding?
Well, my appointment order is, at page 23. First, as approved by the cabinet, such and such for creation of post engagement in temporary basis and reference to the competition submitted with director data such and such with a view to effective tackle the pandemic. 19 state and interested the public service partners please to engage the following persons of research scientists. Then, my name appears as serial number 2 to 6. Then, motion mechanical to page 26. At the request of the government.
Otherwise, it is clear, clause 1.
There are, I'm coming to that. I'm coming to it. Now, what has happened is, motion mechanic come to, motion mechanic on the page. Motion mechanic on the page 40. 40. The initial recruitment was through after improper open advertisement. Temporary appointment was through an open advertisement. Then motion mechanic on the page 47. The cabinet thereafter took a decision the cabinet also took a decision, my lord, to go for a special recruitment test on that dispensation for COVID communities. My lord, this was the subject matter, the decision of the policy decision of the cabinet for a special recruitment test as a one-time dispensation, my lord, was upheld by the single bench and division bench of this honorable court. So, my lord, at page 47, paragraph 4, in consultation with the department, it has been decided to relax the recruitment rules and amended as a one-time measure for a special recruitment drive for medical officer, junior surgeons to be recruited under Nagaland Health Service from such and such. Then Lordship may kindly come to page 49. 6 posts of research officers will be at serial number 10, my lord, medical officers, junior surgeons, such and such. Thereafter, my lord,
We are concerned with which one?
serial number 10. So, my lord, at page 51, relaxation of the rule for one-time special recruitment was approved by the cabinet. Then, my lord, initially the decision was to recruit the post through Nagaland Public Service Commission, special recruitment test, but Lordship may kindly see at page 57. The cabinet, the commission, the NPS, the commission has examined the file relating to conduct of special recruitment drive for appointees in respect of Health and Family Department and conveys the decision of the commission that since the department had withdrawn the requisition post in question on valid reasons such and such, has no comment issue on the proposed special recruitment drive for COVID-19 appointees to be conducted by the special Health and Family Department as the whole exercise is within the prerogative of the department. So, my lord, thereafter, at page 59, again, the department was put up to the cabinet for relaxation of the procedure so that the special recruitment drive one-time dispensation be done by the group departmental. My lord, Lordship may kindly see at page 60, paragraph 5. Permission will be granted to recruit 4 categories of posts that are yet to have service roles. It would be unfair to leave them out. Subsequently, their service conditions may be subject to the provision of the service rule as in been framed. My lord, the research scientist was created for the first time to the service rule. So, my lord, after next page 61, it was approved by the cabinet. Then Lordship may kindly see at page 62, how I like it. Page 62, Lordship. Administrative approval to conduct written in Viva Voice, a one-time dispensation of special recruitment drive for a specific categories. With reference to the letter in such and such and the subject cited above, as approved by the cabinet on 7 August 2024, I am directed to convey the approval to government to conduct written exam in Viva Voice for one-time dispensation of special recruitment drive of the specific categories. Necessary interventions will be made for conduct of the exam free in fair manner on the earliest written test to be conducted on 26 August, Viva Voice on 27th in August 2024. Then, my lord, next page, in compliance with that, the principal director had issued this direction for exam. My lord, the applicant to collect the admit card at serial number 2. Then, Lordship may kindly see next page. At page 64, the name of the petitioners, my lord, appears in serial number 1, 2, 3, 5, and 6. Then, Lordship, kindly see from page 26 to page 70 are the admit card issued to us. 66 to 70, Lordship. We were issued admit card to appear on 26 and by accordingly. However, my lord, page 71, type copy will be at 72, Lordship. Matters regarding special recruitment drive. My lord, drive copy 71A, but I'm waiting. With reference to the subject cited above, I'm directed to inform you.
Page 70.
Page 71. Lordship, the candidate 71A is a type copy. My lord, on 23rd, by a letter dated 23rd August 2024, My lord, Principal Director was informed by Deputy Secretary with reference to the subject cited above, I am directed to inform you that and that the proposed special recruitment drive will be deferred for 2 weeks. So, my lord, I have copies there. Then, my lord, accordingly, the order was again issued at page 72. It was deferred for 2 weeks. Exam which was supposed to be held on 23rd August. Till then, exam is yet to be conducted. I have approached the authorities several locations, submitted representation at page 73. But, my lord, the deferment of the exam has become indefinite.
You were in service?
Yes. Because, my lord, we were appointed through in the participant and we are continuing. Now, my lord, Lordship, now on this issue, with regard to the special recruitment drive, my lord, the policy decision has been upheld by the single bench as well as the division bench of this honorable court. My lord, will read. My lord is the read from paragraph 4 of the writ appeal. My lord, Justice Devasis Parwa and the cabinet of the governor of Northwest is meeting held on such and such.
No, what are the relief you are seeking now?
My lord, my only simple direction is that, and I go direction be given to conduct the exam because still to the
No, that is mandamus on the first day, it is difficult.
My lord,
Mandamus on the first day is difficult. You can issue notice. Because the mandamus is a question which is too hard.
I know that actually, my lord, this case will be disposed of an instruction because when they are going to conduct the exam, because the decision of the cabinet has not been modified.
Time is short before the vacation, so it will go ultimately.
Lordship, the petitioner, he is claiming his relief under page 61. Page 61, election relief claim.
Is 61, next
This is the decision of the cabinet, Your Lordship. The petition is claiming his case based on this. However, this court in WPC number 239 of 2024, that is by order dated 21/10/2024, has stated this.
No, my friend is.
Will issue notice at this stage? We cannot determine every issue, but otherwise they have made out it. They have made out it. And they have the qualification. They are on job as on date. There is no imminent threat, but question is their government was contemplating a special recruitment drive.
Yes.
We don't know as on date.
No,
Let us.
Lordship, the face is like this. We are also for them. We want to conduct a special recruitment drive. But so many litigation has approached this court and they have stayed the cabinet.
No, my lord.
So we cannot go ahead.
I'm submitting the interim
Yes,
order.
otherwise we are for them.
My lord, I am submitting the interim order. Interim order has only, my lord, the interim order has only state for the 98 doctors, not the whole. Lordship, you can see in the interim, last page, some medical doctors is approached challenging this special trial. And my lord, in the interim, considering the sufficient welfare relevant counsel for the party, and also fact, since circumstances of the case, the minutes of the cabinet meeting here discussed and such a additional laboratory approving the realization of COVID-19 appointed to departmental promotion in relaxation of approved procedure in so far as 98 medical officers are concerned has been interfered with. Our case is not being interfered.
I think there emerges some opponents to those doctors.
The cabinet memo includes their polls.
In that, one by one, madam, one by one, that in that petition, I think the petitioners are what? They are also doctors. They are also doctors.
They are
medical officers. Doctor, I allow me to elaborate. My lord, 98 doctors are medical officers also. My lord, a special recruitment was to be held. Now the this night so against that because total 280 posts. which is inclusive of six research scientists, 98 post-medical officers. Now the 98 medical officers, some doctors approached this honorable court on the ground that the special recruitment trial is in violation of the service rule of 2006. Accordingly, my lord, and the prayer is only for 98 doctors, not accordingly specific indifference was there.
Otherwise, where from it is indicative that any kind of selection process was undergone?
My lord,
Anything?
yes, my lord, I have shown the advertisement.
Advertisement, where is that?
My lord, my lord, at page 40, is the advertisement.
That is the initial appointment, your lordship.
Okay, some kind of,
Yes,
some semblance of selection process was undergone.
yes, was an advertisement. There was an open advertisement, and that accordingly, my lord,
So basically, this 40 advertisement, 4th August,
yes,
and you have annexed your appointment order earlier to that.
my lord, after this,
No, no.
no, in response to this,
No,
I
no,
appear
no.
for interview.
Pursuant to this advertisement, you
Doctor.
appeared,
Yes.
and thereafter this page 23 appointment order was issued.
Exactly, Lord.
Oh, that is why
Lord,
it should have been chronologically,
Yes.
but you have annexed this
No, my lord, why I have annexed it?
because our mind is set up, everything goes chronologically.
My lord, why I have annexed it is because I have sequenced with the cabinet memorandums. My lord, lordship, may kindly say page 40. There
No,
are,
at this stage, we are issuing notice.
Yes.
Yes.
Otherwise, lordship, if you come to page 72, the medical doctors, junior dental surgeon, the MOIUs, the research scientists, there are.
They are research scientists.
Yes, that go for special recruitment drive, and this special recruitment drive has been stayed by this court.
Ah.
Yes,
no,
No, no,
only for
doctors.
Not all.
lordship, when they challenge that,
No, my lord.
decision,
Lordship,
which.
my lord, I hope my lord.
But lordship, this may be issued, though.
Maybe at the notice stage, I don't think such application of mine is required.
My lord,
Heard.
the prayer of the writ petition, in that to that matter.
Taka Masala, senior counsel, assisted by Mr. Counsel for the petition and MSP Sukril and additional advocate general Nagaland. For all the respondents. Full stop. What kind of qualification you have?
We are all postgraduate and doctorate.
Okay.
Postgraduate, because we are eligibility criteria is postgraduate, not we are research scientists.
The petitioners, comma, 5 in number, comma, have joined together to institute this writ petition. Full stop. The petitioners have stated that all of them had obtained. This one, petition number 1 is doctorate or not? I don't think.
Yes. No,
Ah.
only
1 and
postgraduate.
5, 1 and 5 are not doctorate.
Yeah, 1 and 5 are not.
All
Yes.
postgraduates. And the petition number 2, 3, and 4 are.
Postgraduate MPhil. Postgraduate slash MPhil. Some of one have a postgraduate and one have an MPhil.
Okay, okay. Postgraduate.
You know.
And petition number 2, 3, and 4 are PhD degree holders. Full stop. Pursuant to, in response to an advertisement dated 4/8/2022 within bracket annex 4, whereby applications were invited from interested and bona fide indigenous inhabitant candidates for temporary appointment for filling up a number of posts, including 6 number of posts of research assistant,
Research,
research
scientist.
research scientist at pay matrix : 43,700 1,38,500. The petitioners responded by submitting their candidatures. Post of pursuant to, according to the petitioner, the petitioners came to be appointed by an order dated 21/12/2020, Annex 1. Initially for a period of 12 months or till regular appointment were made through the NPSC, whichever was earlier. After joining in the post of research scientist pursuant to the said appointment order, the petitioners continued in their service. It was in the year, the state government decided to initiate a recruitment process through a special recruitment drive as a one-time measure in relaxation of the recruitment rules
For the COVID-19.
for the appointees appointed during the COVID-19 pandemic. Full stop. The cabinet had also accorded its approval on 6/8/2024. Full stop. After getting administrative approval, a decision was taken to conduct retain and viva voce as one-time dispensation and by a special recruitment drive for specific categories of posts, which included the post of research scientist, wherein the petitioner has been serving since their appointment. Full stop. It is Mr. Takamasa, senior counsel, appearing for the petitioner, has submitted that pursuant to the cabinet approval, it was decided to hold the written test and on 26/8/2024 and the viva voce on 27/8/2024 and 28/8/2024. And the applicants, including the petitioners, were asked to collect their admit cards, which they had accordingly collected. Full stop. But by a letter dated 23/8/2024, within bracket Annex 31, the Health and Family Welfare Department deferred the proposed recruitment drive initially for a period of 2 weeks. Subsequently, again,
Only once.
only once. Full stop. Thereafter, there is no communication to the applicants, including the petitioners, who are allowed, who have been, who have been allowed to participate in the special recruitment drive as to when the special, written test and vivacy are going to be conducted.
And no reason
Full
whatsoever.
stop. Mr. Takamasa has contended that the deferment of the special recruitment drive has assumed a character of indefinite nature. Hence, the repetitions. First, issue notice returnable on. Yes, madam, when? 3rd of February? 3rd of February,
Well, Lord, may I pray that in January, because it's about something to do with exams.
2024, 24,
24.
January?
January.
No, still you'll have 27 January, still you have 10 working days after the winter vacation. 27, 1, 2024. As MS yeah, okay. So is assisted by Mr. N. N Long. Mr. So learned counsel for the petitioner shall furnish requisite number of extra copies of the writ petition to Mr. Long Kumar, learned state counsel, along with annexer within 2 more. Otherwise it will be different. Oh.
May I pray, Lordship, that the agent receive instruction that the recruiter. Yes.
During the course of the day. Full stop. Having regard to the grievances expressed by the petitioners in this petition, learned additional advocate general, Nagaland shall obtain instruction as regards the special recruitment drive as to when the special recruitment drive is going to be held by the next date of list. You come, yes or no, it is up to you. I'm not saying it is not a positive direction, madam. Why you take everything as a direction?
From the supplementary cost list for motion, item numbers 43 and 44.
I love the embryo for petitioning in the main case, and I have been filed by my brother, ED. We have a consistent prayer that we for a few times a day, that we spend a bit more session of meditation.
Yes, Mr. Gupta. Then when? Immediately after reopening?
Usually, this are just 21st of February.
21st.
This
Okay.
Nagas.
Tuesday. 21st February. No, it will be too much. Stay is too much. That cannot be. You are enjoying a 30-40 days holiday. No. Yes, you tell me it is your packeting petition. You choose the date. I'll accept that. Yes. Okay. 23rd. No, I'll prepone then. You agree to that? It is he. So how many here? 1 or 2?
43.
Okay. Separate orders, but same. Date is fixed. Mr. Heard Mr. A. Joe, learned counsel for the petitioner in 44
Yes.
and the opposite party
Yes.
in 43. Also heard Mr. Y.P. Gupta, learned Central Government Council for the applicant in 43 and the respondent in 44. 45, 46 the same over here. Learned Council for the parties have made a joint prayer to fix the case on 27/1/2024. In view of the joint prayer so made, the prayer is accepted. Release the case on 27/01/2025. Similarly, 45, 46. The interim order passed earlier shall continue till the next date of this.
For motion, item number 47.
Yes, Mr. Lipa.
In the present case, the petition was tried by the summary or some type of court. Then he was imposed the
We have to issue notice then.
should notice. Or if the record of the summary court proceedings will inform.
Which one? Which one? Order? Order?
It starts from page
Impugn order?
59. It is court proceedings, so the entire court proceedings.
Okay.
in the
Heard
penalty-
Mr. Lima Wapang, learned counsel for the petitioner, and Mr. Yangarvati, learned Central Government Council, for all the respondents, full stop. Agreed by
Sentence of dismissal.
agreed by his sentence.
Should become the page number 70.
7. It is dated
Should is dated 1st September 2021. In the first part, in the bottom leaf inside, the date is mentioned.
agreed by the finding and sentence recorded by the Samari Assam Rifles Court on 1/9/2021. The petitioner has preferred this writ petition. Full stop. By the
Should be challenging in the page 70. This is an order passed by the appellate company. 2nd
Okay.
September 2022.
now, what is the punishment there?
The dismissal concerns.
By the order dated 1/9/2021, the petitioner was dismissed, has been dismissed from service. Full stop. Thereafter, the appellate authority had also dismissed his petitioner's appeal on
2nd December 2021.
issue notice returnable in 4 weeks, as Mr. Yangarvati, Learned Central Government Council, has appeared and accepted notice on behalf of all the respondents, issuance of so-and-so dispensaries by tomorrow, extra copy. Extra copy by tomorrow?
Should the report the summary.
By tomorrow.
court
Full
proceedings.
stop. Mr. Yangarvati, Learned Central Government Council shall make endeavor to obtain the relevant records regarding Samari Assam Rifles Court proceedings.
For motion, item number 48.
Chinglu. Yes, what is the prayer of Chinglu?
For addition of process and so. Completed 30 years.
Okay, heard Mr. Moajami, Learned Counsel for the petition, and Mr. N. Angami, Learned State Counsel for all the respondents?
Yes.
It is a case of the petitioner that he has completed 33 years of service and is enjoying scale of pay. Scale of pay. Full stop. the petitioner. Mr. Zamir has submitted that the petitioner is entitled to be regularized in terms of the office, in terms of the scheme and policy notified by the state government in its office memorandum dated 17/3/2015. By this time, I have memorized the date, but by my next visit, I'll again forget. Issue notice returnable on in full as Angami has appeared accepted. By tomorrow, extra copy.
For admission, item number 49.
We have 30 minutes only.
Because substantial hearing is done, I'll only supplement with some judgment, that's all. And I'm told my letter will adopt as sufficient.
Okay. Mr. Anil, you give a short synopsis of your argument by tomorrow. Also, you.
Hello,
Because after going to the principal seat, I may forget
hello,
with a barrage of cases.
I'll only give the timeline, the dates. The last time submitted, yesterday submission. Advertisement was held on 21/11/2015. Gotcha. There, mother, 53, 30, 20. 50 for written, oral, 30 for oral, and 20 for work experience. Thereafter, my lord, warning letter was issued on 8/2/2016.
You'll be giving a date tomorrow? List of date?
Lordship, yes,
Okay.
you give, I'll give.
At this time, I'm not,
Yeah,
do not have the energy to note down.
Mama, I'll give the list update tomorrow.
Sure.
But then, just.
No, I'm hearing.
Yes. Then, my lord,
I am looking at the documents, no issue.
yeah, then warning letter was issued on 8/2/2016. Lordship. And my lord, in the calling letter, it was further notified, amended to 60/30/10.
Yes.
Petitioner had no grievance with regard to the amendment of the impeachment. Then, my lord, a board meeting was held on 12/7/2016. And in that board meeting, Lordship, it was further notified to 60/25/15. It's in the comments I have mentioned. Then, my lord, it was notified. And, my lord, the written exam was conducted on 13th, the written, thereafter, my lord, oral review was conducted on the next day on 14/7/2016. So, my lord, when the oral review was conducted, it was as per paragraph 11 of the Dutch law affidavit, they had already notified in the notice board how much the candidate has scored in their work experience. I scored 12 out of 15. The petitioner scored 5 out of 15. So it's not the question of excess marks. That was the simple facts of the case. So the issue is whether rule of the game has been changed after the game started or after the game is over. Now, my lord, in Manjushri, till Manjushri case, my lord, no distinction was made between the minimum eligible criteria in the proceeding. All was treated without distinction. So, my lord, the Honorable Supreme Court is headed to make a reference that any the two state, firstly, Lordship, the Honorable Supreme Court held that the minimum criteria cannot is changed in any stage of the proceedings, examination. Secondly, however, with regard to the procedures, whether some discretion should be given to the competent authority to the authorities who that is select the best person. That was the reference. Then, my lord, then thereafter, my lord, that the judgment, the two judgment were conflict. Now, my lord, that Sivananda case on procedural and negotiation, which is the expectation, and my lord, however, my lord, in that paragraph, in that Sivananda case, my lord, in paragraph, my lord, 55 onwards, it says that though the respondents were appointed. Malad, after the change, after the rule was changed during the process, because Malad, the minimum marks was prescribed after the exam was offered by the Kerala High Court. But another Supreme Court says, since the petitioner respondents had served continuously for more than 6 years, their service should not be-
Otherwise, that is a case of departure from the statutory rules. Sivanam.
Malad, yes,
And those are case of judicial officer grade 1.
yes, but the fact remains that that benefit was given. So whether that benefit should be given to me also, because I'm serving.
That will be examined.
That has to be examined because my date of, I'm serving for the last 8 years. I have closed more, this is my date of birth. I am now, I've been complete 41 years in the month of January, this is my date card. And I'm serving since 2016, that is one aspect of the matter.
One aspect. It is very, on the very first date, 28/9/2016, your appointment has been made subject to the outcome of the writ petition.
That what it is, but
Whatever is there, that sword is hanging.
yes, no issue. But the fact, but
Now, Mr. Angami, do you have any vacant post? Because of the submission of Mr. Takama, suppose if I hail any vacant post in your Rajya government. Because here are two candidates. If the writ petition is allowed, then respondent has to go. If the writ petition is dismissed, no question,
yes,
right? But if the writ petition allowed, but because of his extensive service of about 8 years,
more
suppose,
than 8 years.
suppose, to take a view that appoints the petitioner, suppose, do you have any vacancy?
So we can appreciate the fact that I was selected as a senior inspector in the.
No,
corporate
I am
department, and
trying to balance the equities.
Yes, that is one. Now, Margaret, put the question of equity. I am coming to another thing. Logic. Because,
Those are judicial officer grade 1,
Margaret, I have come to the officer.
cannot be equated with an LDA.
Margaret, I'm coming with the case of a trial. Margaret, 2001, 10 SCC, 51.
Because all these judgments should, constitutional judgment will have prospective
Margaret,
effects.
that's why I'm coming with that. Margaret, in this case, in Maharashtra, Margaret, interview was conducted for the post of trial. And Margaret, initially in the 1985 notification, the written days for oral, it was 25.
Because in Sivananda, operation was successful,
Patient time.
patient died.
Yes. Now, Malad, here similarly, Lordship, in this case, Malad,
Yes,
the interview was 25 marks. Initial notification of 25, but in 86, but then the notification came in 86% of that, which reduced the interview mark from 25 to 12.5% in this case. So the Honorable Supreme Court said, then Lordship, you can say page 55. Page 55, paragraph 5. That is all mentioned, but to save time, I'm reading the last two lines. It is in repetitive held that this court of the rules of the game, meaning verified that the criteria for selection cannot be altered by the authorities concerned in the middle or after the process of selection has commenced. Therefore, a decision of the High Court to the extent it pronounced upon the invalidity of the circular of 96 does not merit acceptance in our hand, and the same are set aside. Then paragraph 7. Paragraph 7. And on an overall consideration of the above these factors, we have to view that this is the case most suitable for adjustment of equities, taking into account the fate of the drivers who already got appointed in serving all along though subject to the result of this appeal, the petitioners are only intend and number and their claim to be considered for appointment favorably keeping in account their performance in driving test, that the marks obtained by clerking the said test and personal interview and appointed them unless they are medically found unfit for the post. This would help to give acquiescence to the controversy with reference to the selection on hand and avoid reopening the selection process which is beginning afresh. This will give the person who have been serving for quite some time for potential period.
This is open for the Supreme Court to do ex debitio justice.
My lord, I'm only pointing out.
That is why I have asked.
That is one. Now, my lord, on the issue, my lord, since that judgment has been referred, I'm not repeating my submission yesterday. Lordship, my respectful submission is in Desh Prakash. My lord, it was clearly held that some discretionary power should be given to amend the procedures, provided it is notified to the petitioner, to the parties in the evidence. That was it. So, my lord, here, at every stage, the petitioner, calling letters, my lord, it was notified, the procedures, with the substance. Then, my lord, a day before on 12th, decision was again 12th, and it was notified in the court, everyone observed without legal. So, my lord, at every stage, for amendment of procedures, there was no discrimination of.
No, what is the response to that averment?
My lord, it was
What was the response to that averment by the
Can you
petitioner?
allow me?
That notice was
Yes.
Oh.
Kindly allow me, lordship.
of the petitioner in reply?
My lord, can you allow me? My
Only that
affidavit?
statement, only that statement.
Yes, paragraph 7.
Official one,
Paragraph 7.
not private respondent's affidavit.
My lord, paragraph 7. Then, my lord, paragraph 7 reply, he said, paragraph.
Where
8.
they have said it was hanged,
My lord, paragraph 7. To the official. Paragraph 7, the last, in paragraph page 3, lordship. Then paragraph on the bottom.
and what is their reply?
Paragraph 8.
Which part?
Paragraph 8. My lord, that will refer to statement, paragraph 7.
Paragraph 7.
Yes. Paragraph 8, okay, paragraph 8 is replied to paragraph 7.
No, in paragraph 6 also they have said.
Yes.
They have denied.
My lord, specifically, my lord.
Paragraph 7, they have denied.
Then, lordship, I am coming to a judgment of this honorable court. My lord, 2016 5 GLP 506.
Yes.
GLP.
2016, volume 5. I'm reading paragraph 7 numbers.
Page two.
Page 506.
506.
Then I'm reading,
Yeah.
I'll read two paragraphs. Paragraphs 7 and 8. Very good. Very good. The case the question of the legal and this will apply for the proof of the legal or the legal and the case of the mark. That's in the cover. Collaborated the selection board for regulation, exercise and verification, but all that was really required. Not in the position of for the trees, not the recruitment that we discussed. That's big of this technique, you know, the order to work more hard and possible and mark the mark for the that means that in this way, in which and through the three-tier process of written, practical, and debug standard, the exercise undertaken was not found to be so initiated to deserve the influence of tribunal, hence direction was issued to the appointment of the first merited candidate by altering allowing her number such instead, but at the same time, the tribunal did not such and such in this decision was upheld by the High Court through dismissal of the BBC filed by such and such. As regards the process of general selection, the tribunal did not find any major deviation to warrant the indifference with the selection process. Accordingly, it been found that the respondent was recommended on the basis of bona fide process, ordered her appointment as a first merited candidate. The view taken by the learned tribunal was with reasonable view and great equity consideration to shortly stand with the applicant who was recommended on the basis of the performance in the recruitment exercise. We can also be unmindful of the issue made down the such insight where a Supreme Court, while examining the mistake committed by the recruitment body, refused to interfere with the recommendation on the account of equitable consideration. This decision at the episode was really relied by the tribunal in continuing to release the applicant. Then, my lord, in the same page, in the same book, my lord, Dr. Mechanical, go to page 267. I'll read only one paragraph. The last paragraph, 41. This is Ujjal Kuyan first.
Yes.
Page 41. Cancellation or portion of a selection process is a drastic measure and therefore should not be resorted to lightly. In favor of the court should be to save the selection and not to adopt a fault finding approach. Of course, this is not to say that anomalies or illegality should be overlooked, but while striking and anomalies or illegality, the endeavor should be to remove this without annulling the selection process. Only if the anomalies or irregularities are so grave as to strike at the root of the selection, then the drastic scale of consideration or anomaly have to be resorted to. However, in so far as the present case is concerned, as discussed about anomalies pointed out that the petitioner are not of such magnitude to render the selection invalid. To save that, I'm only reading the last paragraph, I'll give the citation. Now, my lord, last leg of submission, my lord. Hello? Challenge after participation in the process. This is now taken in paragraph 7 and 11 of the Raj Government's affidavit. Also that the petitioner had appeared in the examination without any complaint, no representation whatsoever has been submitted, and now after being declared unsuccessful, the petitioner has approached this court. Now, my lord, on this case, my lord, I will invite you. I should be fair to this, my lord. In Salam Samarchi 2016 10 SCC, that Manipur High Court judgment, which was another reference case. In that case, my lord, for division officer, the exam was conducted. 50% was the criteria, lordship, and there was no minimum marks for order. After the exam was over, the full bench had decided to impose a lot
40% as a minimum. And a split judgment case, decision of the Supreme Court, which was referred to the larger bench in Text Prakash. Now, my lord, here, paragraph 30, my lord, 2000. 16 days, 4, 3, 4. My lord, can you allow me to read paragraph? I read only 2 paragraphs. Oh, yes, and sorry, I missed the wrong one. Lordship, I'll read only 2 paragraphs. Paragraph 31st. This is the opinion of Honorable Justice Panumat. In yet another aspect of the matter is that the petitioner participated in the selection process in only because on the final result the petitioner being unsuccessful, he did not turn around and contain that the criteria for selection was changed. It is fairly well settled that candidates having participated in the selection process without any progress cannot be allowed to turn around and question the very purpose having failed to qualify. And Mandala said that Jamil Kashmir is well settled that if a candidate takes a calculated chance and appear in the interview, then only because the result of the interview is not palatable to him, he did not turn around and subsequently contain the process of interview was.
Merely a statement is not sufficient. I'm not satisfied with that particular statement.
The document also you can see that. Okay. What you can see the documents are good. Page 11. And next page 11. This is decision of the court. It was referred as yesterday. We have it now.
This I have seen.
Yes. So, my lord, this was a decision taken. This is the minor.
Decision taken is okay.
Thereafter,
What kind of notification?
The statement is that a copy of a copy of this decision of the selection form will be put motion to be.
Is it a notice board? Merely hanging in a notice board will sufficient, will be sufficient. Please submit on them. Law is well settled. That once participated, he cannot turn back, but there had to be notice. Merely in the file, this is a file proceeding. Where is the notice?
Besides the statement in the affidavit,
And they have denied.
The point is this.
There has to be some tangible thing.
Yes, document that I appreciate this.
Merely hanging in a notice board is not a notice. That is also settled.
Then what about the calling letter?
Calling letter, yes, that will be okay. But where is the notice?
The point is.
Question is notice. Then this will come, this proposition that after being aware of the change of criteria, the applicant participated and then he cannot turn back. That is settled. Hanging in a notice board is not notice, that is also settled.
Yes. In fact, if you look at the paragraph 58, the other judge deferred to this view.
There are 3 judges there already, so I am not split verdict. I am not interested. There are 3 judges' decision on the notice. Hanging in the notice board is no notice. So split verdict, I am not going to. I have to follow that only.
I'm only referring to be fair because this was preferred. That's why I'm referring to. Not for other reasons, because this was one of referred.
Because
Yes.
about this
No,
notice.
the only point is if I go by lordship's state view, that.
Tentative view,
Yes.
I am not taking any final view.
This was there.
I am asking a reply from you.
I'm coming to that. That's what I'm replying to the specific reply. There was an advertisement, conditions were given. Thereafter, in the calling, the petitioner, what the petitioner is praying for. The petitioner is praying for, insisting that the amendment made in the calling letter should be the basis. Not the advertisement. So my point I'm making is, 3 stages. If the petitioner had insisted that we should be on the basis of the advertisement,
then the matter would be different. But here's a case, lordship, where the petitioner is saying that I have no prejudice against the alteration notification in the advertisement. I am happy with the calling letter because calling letter, the terms and conditions in the calling letter is in my favor. But the terms and conditions in the calling letter that in the advertisement is subsequently changed by issuing a decision in the notice board. That is not against, that is against my interest.
It is not the case covered by any other case because here changes in criteria took place twice.
Well,
Is it not?
the issue is
Twice?
yes.
Twice.
So the issue is, my lord, the
According to the convenience.
my lord, appropriate and inappropriate. So my lord, I will work. That is why, yes, since yesterday I am witness, my lord, that had this stuck to your claim on the basis of the advertisement. Issue would be different. But my lord, he also accepted the change in the advertisement and by in the calling letter. Calling letter is not advertisement, lord. If, my lord, there was an amendment to the advertisement, that's a different issue. Advertisement, my lord, has given a go by all of us. So in that view of the matter, my lord, my respectful submission is that the strict condition that the advertisement should be the case is not applicable in the present case. So in that view of the matter, my respectful submission is that, my lord, though that, my lord, it is not a case where another notion may also appreciate this. When the interview was conducted on 14, oral interview was conducted. My lord, let us presume in that it is the fact that the petitioner was not aware. Let us presume in that that you were not aware. Let us go by ground. That you were not aware of what has been defined.
Yes.
However, my lord, in the present case, the interview board who conducted the interview on 14 were very much aware that oral interview is 25 and, my lord, work experience is 15. My lord, with the case of the other cases which have been referred, starting the emergency onward, in all those cases, the local Supreme Court has said that no, it's a case where the interview board were not aware on that day that there's a minimum request for a minimum benchmark for oral. So and on that presumption, the examination was conducted on that premise that there is no minimum. Here, my lord, the interview board was very much aware that these 25, 50 is aware of discrimination and unfairness to the parties. That is the distinction I'm making in the present case with others. If the interview boards were not aware that it is 25, that is out of the 25, 15, will say that discrimination is there. But interview board was very much aware because it is decision of the board that calling letter it has been amended. Now it has amended from 25 to 50, not 30, 10. Accordingly, without fault, nothing interview was conducted.
Yes.
So the only issue is, whether it is in the process, whether it is violation of 14 and 16 so that somebody is prejudiced. But nobody is prejudiced here. From the because the in review of other the authorities, the board were very much aware of what is happening. So that aspect we take into consideration now.
Yes.
I will submit our written statement tomorrow. What time, Lordship, by what time? Because if Lordship is meeting by afternoon or.
Give it before 12.
Okay. We'll get ready at what? Yes. So, my lord, whether there was any, and Lordship finally, my lord, that problem minority. Because there's no service food and the relevant portion is 3.6.
So unlike other recruitment lordship, the Raj Bhavan, appointment is Raj Bhavan, but not have the Raj Bhavan has some extra
Full freedom.
lordship. That aspect also they will be taken.
Yes, anything?
I don't know, the thing will submit it now.
Right. So Ajo. And Mr. Taka Kichul and counsel for the petitioner. And Mr. Takamasa, senior counsel assisted by Mr. R.N. Long, learned counsel for the respondent number 6 also. Also heard Mr. K.P. Angami, learned state counsel for respondent number 1 to 5. Arguments are heard. Judgment is written.
Finally. Lordship,
Otherwise, proposition is that if something is sent to the Supreme Court for reference or pending reference,
Lordship.
but the court has to go, is whatever is the binding precedent on that date. But I don't know for what reason.
Here. Now, the hearing is concluded. It is for my interest that the case today, so I will keep.
Not that.
No, I'm not taking. No, I was also on the other side, so I know the tricks and the crafts. Without saying so, I also know. Mr. Mojui, but somehow we have to miss the bus. What to do? And because my brother has also gone up all this.
Yes.
I have gone topsy-turvy. Actually. Otherwise, such number of cases would not have been listed today. So somehow, you're there.
My colleague.
Mr. Yes, you are there. After vacation, not possible. Item number, most which item? Next item. You have fine. Item number 50. File. I'll just order that it is to be kept in the record. That will suffice, I think, for your further submission on the next date.
Yes.
I think it was placed by Mr. Jimomi. Okay. I can record his name.
Yes,
That-
Your Lordship, please.
And Mojui. Learned counsel for the petitioner. Mr. B. Jimomi, learned state counsel for the respondent number 1 to 6, and Mr. Bendang Wabang, learned counsel for the respondent number 7 to 11. Hard. The instruction, Mr. Jimomi, in reference to the order dated 9/12/2012, 24. Okay. The document, the letter bearing number so and so, dated 10/12/2024 of the Deputy Commissioner Chumuke Dima is kept with the case record, marking it as document X. Post of as sought for and as agreed to by the Land Council for the parties is the case on. I don't know, I have fixed many matters in the January.
Yes.
And then somewhat in February, 3rd of February. 3rd of February. Yeah. Mark, keep it, in the record, no? This one. By putting a tag X. And keeping it here. That answers your
May I please mention item number 28, Your Lordship. 28. The Lordship here, I am here to receive, I'm informed that the case of the petition is being sent to the cabinet for consideration. However, I have not received a hard copy. Lordship, so if I get the better come up on February so that I can find my deeds by way of
Here, the petitioners are from the first of retirement, and this is a government case, and they are eligible for regularization. Under the office memorandums and March 2015, and all the steps. is being
How
taken by
covered
the
case?
system.
How?
So they have completed.
Covered case by office memorandum perhaps?
And all the steps have been taken. by
Okay, I will
the-
put it on 16 hour reopening.
reopening, not opening. Because Your Lordship, the latest,
Ah,
the petitioner who is going to retire early is on on April. So even if the battery comes out on February, I think
okay,
nothing harm will come to them.
okay. 28. Miss Kishore Learned Council for the petitioners is heard, and Miss Livika, State Council for the state respondents. Post of MS Livika 28 is there. MS Livika has submitted that the case of the petitioners is placed before the state cabinet.
However, I did receive a
Ah,
hard copy.
She has received a verbal instruction that case of the petition is presently pending before the state cabinet. And she has not yet received any instruction in writing.
Yes.
Full stop. She has submitted that if the case is posted in the month of first week of February, she would be able to place written instructions. Full stop. In view of mission made by MS Livika, lease the case on so and so. First week of on a date in the first week of February, commencing from 3/2/2025.
Here, I also did mention item number 53. But if you can come after the petition.
Okay. Moajamir. Huh? You are there. Petitioner. Yes, name? Solo. Your name? Sisa Jamir. Land Council for the petitioner. Moju is there. Okay. MS Libika, Land State Council, and Mr. Moju, Land Council for the respondent for here. List the case as sought for by MS Libika, list the cause, data and swing interpretation.
Item 38 also.
It will automatically go. Automatically go. Is it not?
Increase in logic. Lord, if my 11th friend agrees, can we fix the matter, item 26 and 27, with the 720, putting the application there?
That
Yes, I was submitting.
I am not in favor of pardoning the division bench. You make a mention there, then you make. Otherwise, I don't give such burden on a vacation bench.
Lordship, retired employees who similarly situated person has already received.
You make a mention before the division bench.
Lordship. Otherwise, Your Lordship, as far as item number 27 is concerned,
I don't grant any permission in principal seat to be listed on vacation bench.
Or can it be carried over tomorrow, no? 26.
let it be
It
listed.
is not
after-
possible, Mr. Seki, please
Well,
understand also my.
Yes, it's correct.
I'm sitting here 440 now.
yes, your lordship.
Yeah,
I
make it-
sincerely appreciate your lordship's effort.
So what to do? We'll go after vacation.
Yes.
Retired employees, I was concerned.
Concern is okay, but possibility is also
Yes.
should be there. Which one?
Item 26 and 27.
Okay. As sought for by Mr.
Lordship, if I may, Your Lordship, as I was saying, Your Lordship, in item number 28, this honorable court has already passed an order on 6/12 to be listed,
27, you're talking about 27.
27, Your Lordship, yes. To be listed on the 24th of January next year, and to let the affidavit be filed by the state respondent. The order is already there, Your Lordship. I don't know how this matter is.
I submitted
Yes.
a mention memo the other day, your lordship, to be listed along with item number 26.
Lordship, since that order is already there, Your Lordship, it may be listed after the vacation so that I can also get the necessary.
Joshua Seki, Land Council for the petitioner. and Mr. Ann Angami, Learned Counsel, State Counsel for the respondents are present. Place the case on 24/1/2025. Full stop. The parties shall complete the exchange of pleadings by the next date of listing.
I'm yet to receive instruction, Lordship.
My lord, that should not be an issue because there's already an instruction item 26 and they are the same case only. Your Lord.
Shall make endeavor
Yes,
to complete the pleadings,
I deeply obliged.
exchange of pleadings by the next date of listing.
Deeply obliged.